All right, we are back in our public hearing, and I believe now it is Ranking Member Scott. Do you have another question?
I do have one more. What's the number one reason why these landlords end up pushing for the lapse of time style eviction? Again, the ones, not the ones you listed that end up getting turned into that, the ones that, why, what is the main reason? What's the main reason this actually happens? And again, I know you can only speak for yourself in the cases you're in your firm do, but I'm just interested, what is that number one reason? What's drawing that to actually happen? Again, I'm going to use examples. Is it there needs to be major renovations done to it? Does it, they have family members moving in? What is the main purpose? I'm just trying to understand it so I understand why it's happening currently today. Thank you.
Attorney Chesson.
In my experience, I believe the number one reason is because the cost and difficulty of a successful trial on a lease violation, lapse of time, or a serious nuisance or nuisance case isn't justified if a landlord is nearing the end of their lease and they have a problem tenant who's causing problems on the property, whose neighbors are so scared of the person on the property, they refuse to come testify. So the landlord can't put on credible evidence of the situation on the ground. And so they resort to lapse of time and the likelihood that they're going to have to accommodate that problem tenant for another 6 months or so that they can ultimately see light at the end of the tunnel. That's my experience.
Ranking Member Scott, you good? Okay, Ranking Member Sampson.
Thank you very much for the recognition. Madam Chairman, Counselor, thank you for being here with us. I appreciate your testimony very much. I wanted to just follow up on a couple things that you said, and you just kind of cleared up one of my questions, but I would like you to elaborate if you could, and that is, how difficult is it to bring a eviction for a nuisance or a serious nuisance? I don't remember exactly what the difference is between those things, but it seems to me that it might be difficult. You might have to have the police involved. You might have to have witnesses. You might have to do a lot of things to demonstrate that. And for that to be one of the items that is allowable under the bill that we're debating, it seems like it's onerous to the property owner to try and jump through those hoops. So how difficult it is to get through with one of those types of evictions, through you, Madam Chairman.
Attorney Chesson.
Thank you, Madam Chair. Thank you, Senator. It's extremely difficult. It's the direct answer to that question, and they teach us in law school, when you get asked a question, give a direct answer and then explain. So the explanation is this. If you've got a drug dealer on the property and there was a drug bust, there's going to be a police report, but that's hearsay. So you need the witnesses to the drug bust. So that's the neighbors who are too scared to testify. State's Attorney's Office aren't going to participate in the process and aren't going to let the police officers come in and testify until the criminal case is done. So let's say it's January of 25 and the arrest is made. We've had cases that the prosecutor's office, the State's Attorney's Office, wouldn't allow the officers to participate for as many as 18 to 24 months before we could ultimately put together a credible witness list, because perhaps the police officers were involved in a sting operation in order to catch the culprit. And we've had that case. We ultimately won that case, but it took years before we even got to a judge, and we're able to actually put on that case. The costs are astronomical at that point. But let's take the simple one. It's the neighbor next door who's making so much noise that the grandmother who lives in the house next door can't get any sleep. Well, she's scared to death because she's being intimidated by the neighbor, And she's not going to come testify. She'll complain to the landlord, and the landlord will say, well, we'll do everything we can, but unless you're willing to come testify, we're not going to be able to, prevail in the case. That's a perfect candidate, as Representative Scott asked earlier, for a lapse of time eviction. The lease is going to expire in 2 months. The landlord gives the non-renewal notice, and at the end of the day, ideally they get possession back and grandma gets to sleep at night.
Ranking Member Sampson, sorry.
No problem. Thank you, Madam Chairman. Thank you for that information, Counselor. I'm just out of curiosity, I'm just kind of going through the list of what the acceptable reasons for a landlord to bring a summary process that are allowed in the bill. Thank heavens, non-payment of rent is still included, but it doesn't go any more. It's not more elaborate than that. And I'm curious just to get your feedback to know whether that is adequate to just simply say non-payment of rent. Does that mean, is there wiggle room in there to suggest that that might not be an easy way to go? Refusal to agree to a fair and equitable rent increase. That opens the door for what's fair and equitable, clearly. The use of the property as the landlord's principal residence. In other words, not his relatives or any other person, but if they were going to use it themselves. And then permanent removal by the landlord from the housing market, which I don't know how to define permanent. I don't know how you commit to that, even if maybe it extends beyond even your ownership. Just curious if you have anything you might want to add about those itemized reasons that would be allowed under this bill, whether or not they certainly I don't feel that they're adequate as a remedy. I believe that the end of the lease is the end of the lease, but in the likelihood or the event that this passes, is that going to present a problem for landlords to be able to effectively evict people for cause through you, Madam President or Madam Chairman?
Attorney Chesson.
So Senator, the list is, if you compare it to 47A 23, this proposed bill 6889 proposes to amend 47A 23 little c. 47A 23 is really the place where the overwhelming majority of evictions start. And so the list in 47A 23 includes a variety of theories, is the term we use, theories of eviction that are available. The first that's missing seems to be the provision that addresses what we call unauthorized occupants. I've heard people talk about squatters. I've heard the testimony earlier about what banks are going to run into when they foreclose on a property and there's somebody living there that they don't have a lease relationship with. Typically, they're required to go through housing court in order to regain possession of the premises from the occupants at that point. And they won't be able to, because people who originally had a right to live there, but that right was terminated, or they never had a right to be there to begin with, isn't included in here. And the way this is drafted, it appears as though 47A 23C is meant to consume and eliminate 47A 23. And if that's not the intent, I think there's a drafting problem here that needs to be addressed. But more importantly, there are other tools that landlords need in order to address the situation in the premises. I'll go back to the example that I gave earlier about the drug bust. An unauthorized occupant has to be a defendant in an eviction case. So if the landlord knows that there's somebody living there, they have to name that person either because they know their name, or they have to include a Doe, a John Doe, or a Jane Doe in order to successfully get an eviction under Connecticut law. Connecticut law, in very rare instances, allows for an execution, a physical eviction of a partial household. They're very limited. Where that's not available, you have to have everyone listed, including the potential does, or they have an exemption from that execution. And without these provisions in 47A23, now you tie the hands of the landlord who they can't go for non-payment of rent because the person who lives there and isn't authorized isn't obligated to pay rent. They don't have a lease. Rent only exists because lease exists. You can't bring a case for non-payment of use and occupancy. You can't bring a case because they just don't pay something. It's not one of the options. And so I think that the limitations within the proposed bill, especially if they are meant to supplant 47A23, are going to be quite problematic for in a variety of situations.
Ranking Member Sampson.
Thank you, Madam Chairman. Counselor, thank you very much for that information. That is precisely why I asked you this question. I was hoping we'd have somebody with the knowledge to be able to break this down a little further. I fully expected that the way that this is written is going to leave a lot of other not easily identifiable problems for some of us that don't touch this statute every day. So thank you very much for that. That gives us a lot of things to ponder going forward. I just have one final question, which is just since you represent a lot of landlords, I'm curious just about their your impression of their view of Connecticut's system of laws and justice and landlord-tenant law, and how things are going. Do you feel like landlords are feeling welcome in Connecticut, or are they more and more feeling like maybe this isn't the best way to make money as an investment in the state? Just looking for your reaction to that. And thank you very much, Madam Chairman. That's the last question I'll ask.
Thank you. Attorney Cheston.
So we had a client for many, many years who was one of the largest landlords in this state. They divested of all of the property they had in this state. We had a second landlord, was probably close to the second largest landlord in this state, providing Class A buildings. While most of their business strategy was to, stabilize the community and then sell it, they also then divested of all the rest of their properties as they felt less and less welcome with the laws that they were facing from state lawmakers that were not just tenant friendly, but anti-landlord.
Thank you. Rep Butler, are you all set, Ranking Member Sampson? Okay, Rep Butler.
Thank you, Madam Chair, and thank you, Attorney Chessman. You have put things in clear perspective, step-by-step details. Really appreciate you sharing. I just have two quick questions. You mentioned earlier, which I've heard, and I hope that you could share with me, at some point in time, lapse of time was used to the benefit of tenants. Could you talk about that?
Absolutely. A tenant facing an eviction for lease violation, nuisance, serious nuisance, is going to end up with the struggle that's been referenced here throughout the day by both sides. They're going to have trouble finding another place to live because they've got now an eviction on their record that's going to follow them. And it is a frequent maneuver, mechanism, however you want to describe it, where we will agree with a request from the tenant's attorney. Oftentimes it's one of the legal aid organizations that we agree that the judgment will enter on the basis of lapse of time, as opposed to a lease violation or the nuisance or a serious nuisance that was brought, in order to protect that individual's subsidies. Because although very few organizations pursue it. Under federal law, if somebody has a Section 8 voucher and they are evicted, they are required, the administrator is required to terminate their voucher. And it is a regular, useful tool to allow the landlord to regain possession and allow the tenant to protect their future and their subsidy.
Rep.
Okay,
Butler.
well, okay, just one final question, Madam Chair.
Go right ahead.
Okay, also, you seem to have, just the right perspective to actually see the bill that's proposed. And I'm just curious, do you see any way that this could be modified to actually achieve the intent intent while not being problematic in the areas that you have just outlined for Senator Sampson?
Respectfully, Representative Butler, I'm not sure what the intent of the bill is other than take away lapse of time evictions. And,
Okay.
I'd be happy to answer that question if somebody could illuminate that or illuminate me on that.
That is fair enough at this late hour. But thank you for your testimony, and thank you, Madam Chair.
Thank you. So I have one question. The landlords still have 1 year that they can evict somebody for lapse of time. I'm a nurse, a teacher, 90 days. When you start a new job, that you can be fired for no reason. So the landlords do have an entire year with the tenant that I think in that year you could probably figure out if they're a drug dealer, if they're, going to be a nuisance, if they're not going to pay rent, or even if you don't like them because they have curly hair. So do you agree that, usually you would know within a year whether or not this is going to be a tenant that is going to be successful and going to be able to call that place a home for a while?
I dated my wife for 7 years before I figured out she was the right one.
It only took me 2 months and then didn't last too long.
Well,
That
we-
doesn't, you know what,
we
Mayor,
just-
that's not really a good answer, sir. I respectfully ask
Yeah.
that, we're talking about someone's shelter. So, which is very important, right? That it's a very serious matter, as is marriage to some people. But shelter, you're the landlord. Will you know within a year, most of the time, what kind of tenant it's going to be?
If they are, I think the answer to that is a wide open, there's no way to answer that question simply because that tenant could be reclusive for 3 years, go on a succumb to an addiction and become a major problem.
And that's mental illness. They could also have a heart attack or a stroke and
And
not
they're
be able to
protected by
work.
the existing law if it's a mental illness.
And they should be.
Well,
So
but
thank you.
We're not talking about the mentally ill in this bill. We're talking about everyone.
Yes, we are. So so you don't think that within a year that's all I asked. In a year, do you think it's enough time to be able to tell whether or not it's going to be a tenant that's going to match what the landlord wants?
I've got landlords who haven't been in a tenant's apartment in 5 years. So no, I don't think a year is sufficient.
Okay, actually, now we have Rep. Corpus has a question.
Thank you, Madam Chair. Thank you, Mr. Chesson, for your testimony. I learned a lot through it. You said something that I thought was very interesting, which is that the 2 largest landlords in Connecticut you personally saw are 2 very significant landlords pulled out of the market because they didn't see a compelling opportunity anymore. It was just too hard to do business. And they sounded like they were contributing to the communities of which they were a part. Do you know who
They
took
built-
their place and
They
what
built a
happened?
lot- I'm sorry. Go ahead.
Pardon?
Please don't interrupt. Please let
I-
Representative Corpus
I
continue.
apologize.
Oh, it's okay. Do you know who took their place? What quality of landlord took their place? And what happened to that housing stock? Did it get converted to home ownership? Did it stay in the rental market?
So at least one of those that I was referencing built a lot of the housing stock that they ultimately divested themselves of. And it's a wide variety of where those properties ended up. Sometimes they end up in the hands of existing landlords who are expanding their portfolio. Sometimes they end up in the hands of people who are looking to, enter the Connecticut market. The other company, I also believe, did a lot of development here in Connecticut, and they actually pulled out quite some time ago because they saw the writing on the wall at that time and decided that it was time not to stick around. And very rarely do landlords with portfolios that size find a new buyer that is large enough to handle that housing stock in totality. And so often they're the properties are sold individually in various jurisdictions around the state.
Thank you. Thank you, Madam Chair.
Good? Okay, I think we are all set. Thank you so much, sir.
Thank you for your time.
Yep, thank you. So next we're going to go to Greta Blau, followed by Sophia Wang. Ms. Blau?
I apologize for the mask.
No apologies needed.
This has been a lot, very interesting. I thank you to the chairs and committee, and thank you for listening to my testimony. My name is Greta Blau. I'm Vice President of the Hamden Tenant Union, and I've represented people in front of the Fair Rent Commission in Hamden. And I personally went through a 1.5-year eviction process that we ended up winning. So I can tell you that some of what the Attorney Chesson just said is not exactly how it works, but sort of. I'm testifying in support of HB 6889 regarding eviction for cause, HB number 6948 regarding criminal records and housing, and the right to counsel bill. The two sides seem extremely far apart, and I had a whole thing written, and now I have just a book with a lot of scribbling in it. One thing that I did want to respond to some of what Senator Sampson said. A lease is not a real negotiation like other contracts. So let's be honest about this, okay? It's a take it or leave it situation for the renter. And I wonder if Senator Sampson believes that tenants should try to negotiate longer leases. Maybe that's an option. Also, another response about the number of people looking for housing and how this is going to make it harder for people looking for housing. Well, the result of this will be fewer people looking for housing. So I think that may actually be a good thing. It may give us some time, some respite to figure out what do we need to do to stem the tide of homelessness in this state. I mean, everybody needs to pitch in, including the landlords, I believe. I'm glad that you're going to respond to me, Senator Sampson. So I also want to ask you, what do you think we can do to protect tenants from bad actor landlords, which you do say exist? About what can we do with these landlords who the tenant goes to the health department, they go to the Fair Rent Commission, and then or the landlord wants to raise the rent above and beyond like what is reasonable, and and then they're upending an entire family, and we need our kids to have their friends, we need our kids to have stability just like homeowners do. And so I do want to believe that you care about tenants. And so that's why I'm asking you, what do you think we can do? And I'm also going to say something that you're probably not going to like, but that's okay. I graduated Southern Connecticut State University with a BA in history, and one of my areas of interest is the abolition of slavery. I read a lot of primary materials in my research, and recently I came upon some debates in Congress regarding slavery. And one thing hit me because I was here 2 years ago testifying for just cause. And I remember at that time, and I'm hearing today, an argument being made about property rights being sacred. And I'm here to tell you that was the exact same argument they used. Yes, is property sacred part of the tenet of the American dream, quote unquote, that most of us are never going to achieve at this point? Okay. But do we want to use that same argument that pro-slavery forces use? Another one that they used. It's going to be better for the slaves. It's going to be better for the renters. And I understand these are not the exact same topic. And I'm not trying to do any, no, I'm not trying to do anything. I'm a historian and I see things that have happened in the past and I compare them to now. And you can shake your head at me while I'm testifying. I don't find that to be very respectful, sir.
Ms.
That
Ms.
would be
Blah,
appreciated.
and Ms. Blah, we're not here to debate just ranking member Sampson. You're here for the public to
No,
talk
no,
about.
I'm responding to what he's saying. And honestly, he's the
Ms. Blah, Ms.
I'm
Blah,
sorry,
please,
I'm
Ms.
sorry,
Blah.
Mr. Chair. I'm sorry.
There
I'm
is
very sorry, sir.
process, Ms. Blah, please respectfully. I ask that we're here to talk about the bills. And I probably should have, I'm a bit tired. I probably should have stopped you when you did
Okay,
question Senator Sampson, but I absolutely, Ranking Member Sampson has his hand up and I'm sure he'd like to respond. And let's just try to stick with the bills and not get too personal with this. I know we're
I
late.
apologize, madam.
Okay,
I
I
apologize.
appreciate that. Representative
Thank
Sampson.
you.
I mean, not Representative.
May I
You're-
finish my comments?
Ranking Member
Are
Sampson.
my 3 minutes up, Madam Chairperson?
Yes, they are.
I'm sorry. Okay, thank you.
Go right ahead, Ranking Member Sampson.
Thank you, Madam Chairman. I was going to let Greta have the chance to finish her comments. I don't think she finished her testimony. And forgive me if I shook my head, but Greta, respectfully, you're here to provide testimony, not to quiz me or question my intent or my integrity or suggest that somehow I'm in favor of slavery. So, I mean, I think when you do that to the random person, they're going to shake their head. If I accused you of something similarly, I think you would have the same issue. And you'll have a chance to respond. But let me address your question, which is I'm not on the side of landlords or tenants. Okay, that's the number one problem we have with our society and what goes on in politics in this building. I serve on the labor committee, and every fight over there is between employers and employees, and everything over here is between landlords and tenants. Well, I'm not on anybody's side. I'm on the side of good policy and actual truth and justice. That's what side I'm on. And I just don't believe that this bill is fair. That's all. I think it is definitely heavy-handed and will harm the housing market, which is my number one concern about it. Not so much the actual function of the policy itself, but the fact that this will be seen by people that provide housing as a hostile move by the state legislature. And just like the attorney we just heard from, people are already concerned about being housing providers in Connecticut because they consider it to be a hostile environment. And I believe that's what's contributed to the lack of available housing that we have already. So I'm concerned about every move we make as a legislature being a signal to say, we don't want you here to provide housing, because ultimately that's going to harm everyone. Because what happens is the good landlords are the first ones to leave. The bad landlords are the ones that stay. And there are fewer and fewer choices for tenants. So I have said numerous times today, and again, forgive me for going on, Madam Chairman, I should supposed to be asking a question, but I'm trying to address Greta's concerns. Most of what I've heard from people here today is about things that are already actionable, things that the landlord's doing to them now. And I believe that because of that, there is a way for people to address those concerns. I'm not a fan of using taxpayer money to fund legal aid for tenants, to be honest with you. But the fact of the matter is it does exist. And I think if some of the folks who had expressed their concerns today had actually talked to those people, they might have found a better remedy than coming here to want to impose legislation into the marketplace, which I think will ultimately harm everyone. And I'll also just say one word, which is that property rights to me are sacred. So are every other type of right that we are concerned with, our rights that are natural and protected by the Bill of Rights. It's funny to me that people are here suggesting that tenants have rights over and over again and completely ignoring the fact that while tenants do have rights, so does the property owner. And that's the reason why I keep bringing up property rights and contract rights. And to the last thing I will say in response, Greta, before I ask my question is, you said that contracts, leases are not typical contracts. And I will agree with you that the landlord almost always writes the contract. But the fact is, it is much more negotiable than most contracts. Like if you're going to purchase almost anything in the world, that's a contract also, where you exchange funds in order to purchase the item and you don't have a lot of say over it. If you're going to buy a cell phone plan, it's not negotiable. If you're going to rent a car, it's not negotiable. Almost any type of contract like that is not negotiable. Whereas a lease is almost every time is negotiable to some degree. I have 4 properties and every one of them has a different lease because I made special arrangements with that particular tenant. Now, that doesn't mean that the landlord's going to budge on everything, and it doesn't mean that they should. But at the end of the day, the tenant has the right to say, no, I'm not accepting those terms also. And I believe that the only difference between me and you probably on this subject is that I believe that the actual term of the lease ends on the day that both parties agreed to. So that would be my one question to you, which is, how long should a landlord allow someone to exceed the date that they had been previously agreed to as both parties? Through you, madam.
That person isn't, I'm sorry,
Ms. Blau?
I don't know the procedure, I'm sorry.
Yep, go right ahead, Ms. Blau, and just let's try to stick with the bill, and if you could answer Ranking Member Sampson's question.
Okay, I appreciate your comments. I think what we have to look at is like the lawyer used the examples of the worst possible people, the drug dealers, the person who's going around scaring people. What I'm talking about is single moms who have water coming through the roof into their children's room. And I've seen this happen over and over and over again. And then those people go and try to do something about it, and then they end up losing their housing. And it is a very upending experience. And so for that reason, like, I think, it depends upon the person, but I do think I think that landlords need to recognize how much of an upending of people's lives this is, how much every single year we worry, are we going to have a lease? It is like a huge burden on parents. And so I don't know if there's a specific amount of time. I mean, that's a discussion that could be had. But I do think we have to separate the people who, maybe just wanted them to fix the ceiling. Should that person just live like that and then they get their lease renewed and they're paying for this as well at the same time to live in a place that's probably not as healthy as it could be if they had a good landlord? And so that question is more complicated than just 5 years or something like that. And I think I get where you're coming from. It's a business point of view. It's like a legislator point of view. I have my experiences as a tenant, and I've been dealing with tenants for the past 5 years, and I've seen what happens. And I think there needs to be a further discussion about like people kind of like actually listening to each other and trying to understand, because I think that's part of the problem is like, you guys have your point of view, we have our point of view. And it's kind of like, everybody's like, well, you don't understand. We do understand. We just disagree. And so, and there's semantics about the word eviction and all of these things. It still hits the same for us, whether it's called an eviction or whether it's called your lease is up, your contract is up. And so, so it's hard to give a real answer to that question.
Ranking Member Sampson.
Thank you, Madam Chairman. Greta, one thing I would suggest is I would be happy to have a conversation with you offline so we could actually have a real conversation. we're kind of limited on time here and our ability to interact in a friendly manner. We have to kind of ask each other questions kind of thing. But I'll just say a couple of quick words, which is number one, anyone who's living in an apartment where there is water entering their children's room, that's a bad situation. I would never defend a landlord that is allowing that to occur for more than 5 seconds. You should be able to call a landlord and get someone there this same day to resolve a matter like that. If that doesn't happen, then you've got to be on the phone to legal aid or something like that. And there are remedies. There are remedies. I mean, you know, I would fully expect as a landlord that my tenant would say, I'm not paying the rent till this is fixed. And in further matter, if it's not fixed in 48 hours, I'm going to pay someone to come out here and do it, and I'm going to deduct it from my rent. You know, that's not a best answer either. I don't know that people have the means to make a repair like that, but that's what somebody should expect in those circumstances. What frustrates me is that I just don't know that that's happening as much as is described. Now, there's a lot of people showing up today saying things like that, but you know, how many people actually are here today testifying? Maybe it's the couple hundred people that are in that situation, which is 200 too many. But I don't know that that is a common occurrence across the state. We should be trying to address it. I completely agree with you that we should. But I see that this bill is just something that is using a bomb to drive in a nail. And we can disagree about it. But I would love to have a real conversation so we can share our perspectives. And I'm happy to do that offline. I'm easy to find. You can look me up.
Okay,
Thank you.
thank you.
Thank you, Madam Chairman.
Seeing no other, yep. Representative Sweet.
Thank you, Chairwoman. Greta, thank you for your leadership in the Hamden Tenants Union. I know that you've spent a lot of hours fighting for tenants in various capacities. A very simple question. Do you think Just Cause would help renters in Hamden?
Yes, because the reality of the situation is we're being evicted, and we can call it eviction, we can call it the lapse of time, whatever you want to call it. I have seen, and State Senator Sampson, you know, says the thing about, well, I don't know if that's really happening that much. And I can tell you as a tenant leader in Hamden, this has happened so many times, and I've seen it happen to people in New Haven as well. And it's kind of, I think it's the kind of thing that the landlords know that if they stretch it out long enough, that they can just get rid of the person. And so, you know, so it's easy to say that we should, you know, go, oh, now you just go and call the legal aid. Well, you have to qualify with your income. Also, you can go to the Fair Rent Commission, but you know, that's a toss up depending what town you're in. And also the health department. I mean, we had the health department going into our basement and telling us the mold that was just literally covering everything was not there. And so yes, do we have these avenues to help tenants? Well, in theory, yes. Do they actually work? No. And it's and also, you know, there is a part of me that just feels so, you know, you know, like, I don't know what the word is, but it's like, I'm telling the truth. Like, I really am telling the truth. Like, this is really bad for people out here. And while, like, you know, Senator Sampson may be a good landlord who works with his tenants, he's only got 4 places. So that's a kind of different situation where you can really pay attention to your tenants and all of that and kind of get to know them as people. But, you know, in this case, we really don't have as many rights as it would appear. And, you know, it is very easy to get rid of us. Most of us just give up. So there wouldn't be any you know, trial or whatever for that. So I think it would really help people stay in their homes, and we have to stem the tide of this a little bit. Maybe we could have a time limit. Maybe we could do it for a year until we can figure out these other little things that we can do, as far as like not allowing them to raise the rent like 50% so that they can, you know, get new people in, or certain things like the lease negotiations, or you know, what protections can we come up with for protecting tenants against bad actor landlords that we all know exist?
All right, thank you. Seeing no more questions, we appreciate your testimony. Next, we are going to go to Sophia Wang, followed by Jeff Jentz online, followed by Gladys Silva Perales in person. So Sophia? Oh, hi,
Hi.
Ms. Wang.
Yes.
Go right ahead.
All right, Senator Mark, Representative Philippa, and members of the Housing Committee. My name is Sophia Wang. I'm a resident of New Haven. I'm a tenant, PhD candidate in political science at Yale, and a large member of the CTTU Connecticut Tenant Union, and a member of All In from Milford. So I support House Bill 6889, and I believe all tenants should have just cause eviction protection. So I have been researching about housing policy, tenant and community organizing for more than 2 years now in Connecticut, New York, New Jersey, also abroad in Berlin, London, where I testified last year online, 4 a.m. in London, Hackney, Manchester, Glasgow, and Edinburgh in the UK. To begin with, I really want to say that surprisingly, tenants in Connecticut do not have rights that or enforcement of the rights as a lot of the legislators might imagine. Having been in New Haven since 2019, with 2 years of commuting back and forth from New Jersey, I've witnessed how tenant and community groups and coalition emerge because of this justice gap. It's certainly time for the Housing Committee and legislators in Hartford to listen to people's stories of how policy enforcement, and the lack of it have impacted tenants' lives, family well-being, and for everybody to not live up to a community's full potential for residents of Connecticut. So I want to use my own experiences to tell why this legislative body needs to proactively address this justice gap. Without just cause eviction protection, I knew in April 2022 that my landlord wouldn't want to renew my lease because of the $6,000 increase in property taxes due to the most recent assessment. So I used cell bill pay for all my rent first of every month, and the landlord not only did not renew, but also illegally withheld my rental deposit, setting chips from the wall and blatantly admitted that tech that he used it all to paint all living room and bathroom walls, which we did not even have when moving in. So as a result, we decided to move to Jersey City partially, and I've been commuting. I kept a room on Mansfield Street for my weekly commute. I want to use this example to really counter a previous point made by the landlord attorney about how long the process really be to pursue justice. So as a student of housing politics and policy, I knew that something was wrong. December 2022, I filed my first writ after attending a free legal clinic in New Haven provided by the judicial branch. I've encountered numerous delays for not being familiar my first time of a small claims representing myself, and got my default judgment for $904, including the fee paid in April 2023. The landlord, of course, did not follow the court payment plan. Here, the most important message to all the renters listening to this message is that you need to know your landlord's bank. I started the first financial execution in August 2023 and experienced delay because one, I didn't know that I needed to delay the papers to the marshal's office in person. I didn't know the landlord's bank. I tried the second one in September 2024 and after moving back fully to New Haven, received my money $1,114.65, including two more financial execution fees before Christmas in 2024. Would I be able to do all of the above had I known that the story can also go into my book of my dissertation? Probably not. The energy, time, and knowledge needed to pursue justice on the tenant's end are what I'm telling all of you about the justice gap.
Ms. Wong, your 3 minutes have expired. If you could please summarize.
I will wrap up because the landlord emailed me and saying it's truly a shame that you did not do you did this because it's going to cost you more. And the landlord keep ripping off my private neighbor. I'm happy to answer more questions about further examples, but I just want to close by. It's important we take account of time horizon for policy and its enforcement. It's impacting people's life now, and I'm asking this legislative body to take action now, to not just have just cause bill pass into committee, but really committed to make a vote, and let's see what the vote is about for the just cause bill in this 2025 legislative session. Thank you. I'm happy to take questions.
Thank you, Ms. Wang. Seeing no questions, we appreciate, sorry, Representative Sweet.
Sounds like you're talking about an imbalance of power. I'm not sure we've talked about that yet today. I wonder if you could speak more about that imbalance between tenants and landlords in your experience.
I think like numerous testimonies today can address it a little bit, especially I think in my case, it's really important that the landlord know how much time and energy for me to really fight for the case of rental deposit. So even though he might be suffering a future loss, he was like actually willing to take that risk because, not all like, tenants would do this. And I mean, I was doing it mainly because this is my research partially, right? So for my neighbor who actually didn't even have a lease for many, many years, also had her $1,150 like much more than half of her monthly income illegally withheld because the landlord saying you need to give me 45 days of notice, which is absolutely not true. She didn't even have a lease. For personal reasons, she wouldn't pursue it. Now she's in a senior subsidized housing, thanks to a lot of the funding of the senior subsidized housing provided by the state. So I really want to wrap up as answering your question about what does it mean to have imbalance of power. It didn't start really at the point where you have a lease renewal. It started every second when you are living in a rental property, thinking about, well, bringing this question up about repair, make the landlord not like me and not giving me the potential, like, possibility of a lease renewal. Having just cause eviction protection will prevent this fear. And I think numerous testimonies have covered that. So that's what we're saying about imbalance of power. It does not happen at the time, at the expiration of lease. It happens in every single second that the lease is happening between the tenant and landlord. Thank you for your question.
Thank you. Okay, all set. Okay, now seeing no more questions. Thank you so much, Ms. Wang. And then we will go with Jeff Jentz online.
Good evening, Senator Marks, Representative Philippe. Who else is here? Senator Sampson, Representative Scott, and other distinguished members of the Housing Committee. My name is Jeff Gentis. I'm a lawyer who represents tenants in actions against their landlords, both tenants suing landlords and defending tenants against those suits. The bulk of my experience in this area comes from co-supervising a law school housing clinic. I want to address two quick things. One, I do support the continued funding of the right to counsel, and second, support House Bill 6889, the Just Cause bill. I'm just going to react to a few of the things that we've heard tonight. Lack of just cause right now, the biggest thing that we see is it gives free rein for landlords to retaliate whenever tenants do try to exercise their rights, whether it's starting improper evictions, whether it's starting evictions based on lapse of time. After, we often have to tell people that, where would you go next if you couldn't live here after a few months? And most of my clients are not on year-long leases, but instead on month-to-month situations. I heard some concern about, whether or not we're doing enough to encourage 2 to 4 family housing. We do need that in the state. It's called missing middle for those paying attention to other zoning related bills. And what we really have are local tyrants who use zoning laws to prevent those multifamilies from being constructed. So, reducing this local control would be helpful in that area. Second, the landlords that we tend to see having a tough time with serious nuisance and nuisance cases are those when they get to court that they're not credible. If you have a credible case, there's usually not this type of issue. And, I frankly don't understand the last example that we heard from Attorney Chesson when it came to, even though we have lapse of time on the books now, and even though this bill is not in effect, it still took over, a year and a half to get rid of, a drug dealer in the building. So that was confusing to me. Frankly, I'm all set with the sort of, this politically correct term that's come up in the last couple of years of housing provider. The term is landlord, both under the law and in practice. I also want to address that, the mom and pop landlords, a lot of them aren't even going to be affected by this bill. And they're some of the worst that we see. They tend to be some of the most vindictive, even compared to ways that private equity investors are not. We're also just seeing there's a lot of nasty discourse out there. You have, a lot of the lawyers who do this work cater to some of the landlord's worst impulses. And they come in with a pretty hostile approach into eviction court. And we have newsletters and the like who rile up the landlords out there. And then the last part is I just can't abide these comparisons to marriage. It's just, being married is nothing like being a landlord tenant relationship. So with that, I'm happy to answer any questions you may have. And thank you for your time tonight, and appreciate your commitment to sticking out into the 13th hour here.
Thank you. Seeing no questions, we appreciate your testimony. And next we are going to go to Gladys Silva Perales.
Thank you.
I cannot officially say good morning yet. But thank you for for all the members of the Housing Committee for having me. My name is Gladys Silva Perales. I'm a resident of Newington, Connecticut at Victory Gardens complex where I lived for the past 12 years. I'm a U.S. Army veteran, a mom, and I'm closely involved in my church, and I'm also tenant union vice president. That means I've been elected by my neighbors to represent their interests as tenants. I'm here to testify in support of House Bill 6889, an act concerning evictions for cause. I started organizing a tenant union at my apartment complex last year because of the harassment and abuse of power that I was dealing with at the hands of the property manager where I live. Landlords and property managers have enormous power over our lives as tenants because we all need a place to live, a safe place to raise our families and take care of ourselves. We all need housing. In my case, my property manager likes to threaten me and my neighbors with eviction. She doesn't hesitate to hold homelessness over people's heads as a way to force them to agree to whatever she says, no matter how unreasonable or unfair. For example, I ended up with a notice to quit for quote unquote inciting a riot after holding a press conference with my elected officials. One being Mr. Gary Turco and Mr. Blumenthal. And so it was interesting. We went public on Wednesday, and by Friday I had a notice to quit on my door. Specifically for inciting a riot was what was written on there. You know, another example of evictions from some of the other tenants is over lack of communication. Someone got a notice to quit for a few dollars that was owed. And then when they finally went through the books and everything else, they realized, oh, that was their mistake, not the tenants. You know, another was threatened of eviction because of getting things done, getting things fixed in her home. That was a story all day today, is how many people, you know, they complain and people are too scared now to even say anything about something that's damaged in their home because of it. You know, many neighbors are threatened with eviction for minor paperwork issues or confusion with what's being asked of them. Because I'm a disabled veteran and because of the type of housing I live in, I already benefit from just cause eviction protections. But I can't say the same for everyone. At least in my case, the property manager had to write inciting a riot as the reason for the eviction, an accusation which could easily be disproved. If I had not had just cause protections, my family and I probably would have been forced out of our home already because she wouldn't have had to do that. Gladys, your 3 minutes have expired. If you could
Okay.
please summarize.
I'm almost done. I'm sorry. What I'm saying is I probably would have been forced out if I hadn't had the protection. She could have simply refused to renew the lease and told me to get out. You know, tenants of all kinds deserve protection against unfairness and abuse of power. And just like what was said, two people before me about the imbalance in power, just cause will help ensure that. Please vote yes on this legislation.
Thank you for your testimony. Rep. Turco.
Thank you, Madam Chair. Through you, I'd like to ask a couple of questions, if that's okay. Gladys, thank you for coming here. I know Senator Marks was asking me, the chair earlier, how far of a drive I have, and I said only 15 minutes. So we're some of the lucky ones here, so won't be too far of a commute heading home. But appreciate you staying here with us to almost midnight, and you were one of the first ones here this morning. So I'm glad you mentioned that, you know, what you've gone through in Victory Gardens, and I appreciate you being a leader for your fellow tenants there. Can you tell me a little bit more? I know you said you are protected from the current laws we have in place regarding just cause evictions because of your status.
Correct.
But other tenants in the complex that where you live are subject to that now. Can you tell me a little bit more about that?
So, for example, I've got one tenant that came out of homelessness, came to live there, and she had just from the beginning, she's gotten notices. So she came with a program. I don't think it was CRT. It was some other program that they were supposed to pay for the first month and so forth. They didn't get the money to the landlord on time, so then she ended up with a notice to quit. But it wasn't her job, her portion, and it was a contract between that company or that organization and the landlord. So that started a whole whirlwind. She's one of those people that when I say fear, it is worse than the fear of the Lord on her if anyone comes to her door from the management company, because she just thinks that she's going to get evicted because of the back and forth and how many times they've threatened eviction. People have been threatened eviction. There's notices as far as recertification, and people have gotten the third letter on recertification, but never got the first or the second. And I'm talking at least 7 people in the complex all at the same time, never got the first letter of recertification saying, hey, you know, make an appointment, come recertify. Never got the second one, hey, if you don't recertify. So the third one, of course, it's an escalated format of a letter saying, hey, you're going to get evicted, you know, because you're not recertifying or you're not making the appointment. But they never got the first 2. And so that's the kind of overbearing threat of eviction that's consistent at where we live.
Thank you, Gladys. I appreciate you sharing, you know, what this bill would mean to fellow Newington residents, help provide some insight for me. So thank you so much. Thank you, Madam Chair.
Okay, yep. Rep. Felipe, Chair Felipe is next. I'm just going to say, if you are 89 to 95 online, please get on now because the next person is 96. And if we miss you, you're going to have to wait till the end. So 89 to 95, if you're out there, get on. Otherwise, 96 will be next. Chair Felipe.
Thank you, Madam Chair. I just wanted to highlight a few things. Your testimony hit me a little bit differently compared to some of the ones we've heard today, and especially when you talked about being told that you incited a riot, right? You know, we talk about how there are these landlords, housing providers, whatever you want to call them, and how many are bad actors, good actors, whatever. In this case, you are literally exercising your right to organize, right? Your First Amendment right to speak out and just talk about things in your neighborhood. I'm not even sure what the press conference was about, to be fair. And she says that you're inciting a riot. I just hope that the person that owns your unit at Victory Gardens and the person who's doing these things is listening right now, because regardless of if we pass this or not, I just hope they cut it out. It's a ridiculous way to treat a person. When you talk about the fear that your fellow resident has and the gall of somebody to manipulate that, especially in such a disingenuous way, I just want to say it hit me differently, and I hope that they're listening so they can stop doing that, because you deserve better. And hopefully we can pass this bill, but they shouldn't be doing that one way or another.
Thank you. It was actually to form a tenant union because of all of the bad, you know, the manager and how horrible she's been.
Thank you for your testimony and for your advocacy. It's very appreciated.
Yeah.
Okay, next I see online is, is 96, Mr. Dondre Roberts, followed by, Calder Hudson. Go right ahead, Mr. Roberts.
Good evening, members of the Housing Committee. My name is Donjay Roberts, and I'm a member of the Connecticut Apartment Association, an organization representing over 70,000 apartment homes in the state of Connecticut. I'm a housing provider and member of the New Haven Fair Rent Commission, and I'm also someone who experienced homelessness as a teenager, so I'm intimately familiar with both sides of the arguments put forward today. Our association supports SB 1305, an act establishing a task force to study municipal penalties for landlords for health and safety violations. We support an agenda to hold bad actors accountable. In fact, many of our members are members of fair rent commissions across our state. We do ask that in this bill, language be added to include representation from landlords and builder groups who have valuable insights. We also oppose HB 6889, an act concerning evictions for cause. We strongly believe that a lease has a clear start and end date. As a realtor, I'll speak from experience. A client of mine recently had to use lapse of time to remove unlawful occupants from the home. What had originally happened was I had rented a 3-bedroom to tenants A, B, and C, and midway through the lease, tenant C moved out, and tenants A and B re-rented the room to new occupants without screening or without owner approval, clearly violating the terms of the lease. Problems followed, like late rent, police visits due to roommate disputes, and an additional occupant who moved in who started residing in the apartment living room with a large dog. To try and remedy the situation, the owner and I tried to verify who actually lived there, requesting photo IDs, pay stubs, proof of employment. But the occupants refused. As a result, the owner chose not to renew the lease. This proposed bill will take away the ability for a housing provider to act as swiftly to remedy problems such as these. What happens when neighbors move out because a housing provider has failed to act swiftly due to a problematic resident? Many have pointed to other states today that have enacted similar measures, but I'll point out that the states that have enacted those measures have an affordability crisis. Our organization also opposes HB 6891, an act prohibiting a landlord from requiring a security deposit in excess of 1 month's rent. In my decades plus of experience working in rentals, housing providers typically ask for an additional security deposit if there is concern about an applicant's credit or financial background. Removing this option would lead to housing providers rejecting those who they may have considered renting to previously. We oppose HB 6892, an act limiting the increase of rental charges upon the transfer of residential property to an owner. Many towns and cities increase taxes upon the sale of real property. In fact, I'll speak personally in New Haven. When I purchased my property, my tax bill increased 14% year over year after my purchase. So we believe that this bill will disincentivize purchasing property, especially when we have some of the oldest housing stock in the country. And lastly, we support SB 1307, an act establishing a working group to study and develop the best practices to promote housing growth and protect the state's water supply, because we know that we need to increase housing growth across all parts of the state and also respect our environment. Thank you.
Thank you.
Any questions?
Rep Weir?
Thank you, DeAndre, and thank you for your testimony. And Madam Chair, I just have a couple of questions for DeAndre.
Go ahead.
Through you, Madam Chair. DeAndre, thank you for your testimony. And I think it's admirable, specifically that we have somebody from the housing side taking part in the fair rent process. Can you elaborate on your experience? I don't know to the extent or the how long you've been in this position, but can you elaborate on your observations and experience so far in taking part in this process?
Yeah, absolutely. More than happy to, Senator Representative Ware. So I've been on the New Haven Fair Rent Commission for just about a year. And, I come from a background working in housing and also growing up in rentals. So I thought that being able to be on this commission would allow me to see both sides, both points of view. And I think that, the work that we do, it's admirable. I think our executive director, Bermudez, has done a really great job. We get about 2 cases a day. I think that might be more than other towns and municipalities, but I can only speak to New Haven. I think we really try to, listen to both sides. And I think that it's a great way to hold bad actors accountable. Unfortunately, there are people who frequently come before our commission, none of that being any of our members of CTAA, but it's a great way to hold bad actors accountable. And in my view, I would say that it's working and helping residents of New Haven, and that we are holding the feet to those who are not maintaining their properties. Obviously, more can be done. That's why we support the act that would establish the group studying municipal penalties for people who don't maintain their properties. But I think that the work that we're doing in New Haven and our Fair Rent Commission is doing a great job at holding some of those bad actors accountable at the local level.
Representative Weir?
Thank you for that. And I just have a couple closing statements. No more questions. I appreciate you, as a property owner, congratulations on that purchase, by the way. Referencing and acknowledging, what I've seen as a property owner, as well as are the increasing costs. I have absolutely zero say in what my tax increase is each year over year. It is what it is. The grand list is rising as a result of increased property values, and so it's hard to manage that and budget for that. And those increases, they are what they are, and those property taxes are baked into the total cost. So appreciate you acknowledging that, and also your advocacy for continued want for development, but also keeping groundwater and aquifers and our environment, being good stewards of the environment also at the same time. So appreciate your testimony very much, and thank you for being with us at this late hour.
Thank you, Representative Weir.
Thank you. Seeing no more questions, Dondre, thank you very much. Next in person, I have Calder Hudson. And then after that, we're going to go to line Capria Burkett. Then we'll go back to in person. And then we're going to go to Lynn Haig, Terry Rick. So 97, 98 are after Mr. Butler online. So if you are getting close online, please get online, because I am going to start skipping over you if you're not there, and I'm going to try to stick to it. Thank you. So go right ahead, Mr. Hudson.
Is it just this button, or this is already working?
Yeah,
Sorry.
sounds like you're
Perfect.
on. Yeah.
Swell.
Thank you for your patience.
Thank you all for your patience. My name is Calder Hudson. I'm a CTTU member. I live in Middletown, where I rent in a building which would not be covered by HB 6889, and I am nonetheless here to support its proposed expansion of just cause in the strongest possible terms. We've heard at this point for the last 12 hours from tenants who have suffered under the atmosphere of fear which no-fault evictions existence creates, and many people before me have spoken to that at great length and with great credibility and strength. This fear and the knowledge that you can be evicted for no reason, as well as the knowledge you can be evicted for no reason, is one of many of the proposals. It's one of the reasons that many of the proposal's opponents are desperate to maintain the status quo which exists in this state, which is not very fair to tenants and working people. And that's because the atmosphere of fear serves the business model which predatory landlords in Connecticut are following, which is part of why many predatory landlords from out of state, like those countless members of the public and members of the committee have described today, are such a problem across the state of Connecticut. For predatory landlords, no-fault eviction is invaluable to their business model. It keeps costs low with tenants living in squalor, because those tenants know that they may suffer retaliation, such as an aforementioned eviction for no reason, if they ask for repairs because of unsavory or outright unsafe conditions in their homes. We heard from a previous testimonial about a what-if scenario where tenants are intimidated by other tenants. But the reality is, under no-fault eviction rules, the relationship that exists between tenants and landlords can be very reminiscent to that for many people in this state. The fact that no-fault eviction is also a direct contributor to the homelessness crisis in Connecticut, a fact about which some members of this housing committee have claimed or feigned ignorance over the course of today and previous discussions, is of no consequence to those predatory landlords and is potentially anything from an acceptable loss to a source of fear that withholds tenants from advocating for themselves. An eviction given for no reason, since we've discussed the definition of eviction, an eviction given for no reason leaves someone as homeless as an eviction of any other kind in the state of Connecticut. And I don't think anybody in the state should ever have to choose between living in a home with mold or not having a home to live in. And we've all been here for a while, so I'll leave it there.
Thank you for your testimony and for your patience. Seeing no questions, much appreciated. Now we will go to Capria Burkett online, followed by Deidre Brown. If I pronounced that wrong, I apologize, in person. So Capria?
Hi, I don't know whether to say good night or good evening to everyone, but Senator Marks, Representative Felipe, and members of the Housing Committee, my name is Capria Burkett. I'm a member of New Haven Rising, and I'm here to support HB 6889, an act concerning evictions for cause, and believe that all tenants should have just cause eviction protection. As a tenant and someone who knocks on thousands of doors year in and year out, as a volunteer in my community, I've seen the impact of housing insecurities and the affordable housing crisis pummel our communities, especially Black and Brown ones, over and over. I believe this legislation is essential to ensuring housing stability, preventing unnecessary displacement, and strengthening our communities. Currently, too many CT tenants, like myself, live with the constant fear of eviction, even when we have done nothing wrong. Without just cause protection, landlords can refuse to renew leases or terminate tenancies without providing a valid reason. This leaves families vulnerable to sudden displacement, disrupts lives, and contributes to a housing instability across our state. My husband and I work very hard. I'm a teacher, and he is a member of Local 35 at Yale and also runs a small business, Gorilla Lemonade. We are getting ready to start a family, but it's scary because even though we always pay our bills on time, we could end up kicked out of our apartment onto the streets or back at my parents simply because the landlord decides he could get more money off of a rich Yale student to move into our apartment. When tenants are evicted arbitrarily, the consequences are severe, especially for low-income families, elderly residents, and people with disabilities. Without safeguards in place, these individuals face higher risk of homelessness, job loss, and emotional distress. Connecticut already struggles with an affordable housing crisis, and unjust evictions only worsens this issue. Please stand with working families and pass HB 6889 this session. Thank you for your time.
Thank you for your testimony. Seeing no questions from committee members, in person, we have Deidre Brown, followed by online, Lynn Haig, followed by in person, Sam Pappas. Hi.
Hey, how you guys doing?
Hi, welcome.
Thank you. I just want to say y'all the real rock stars. We're getting close to club hours, and y'all gonna be up, so that's turn. Y'all are rock stars, for real. So I'm gonna start. Thank y'all for being here. Hi, my name is DeAndre Grimdy Brown, Executive Director of Fallen Angels Music, Evolve Love, and affiliate of BLM 860 and CT Cannon Warriors. I'm 26. I was homeless at 19, going from couch to couch and sleeping outside my local skate park heaven and under the riverfront bridge when it rained or snowed. 2-in-1 isn't enough, and giving people that most likely potentially have mental health problems robots on the phone line instead of a person to direct them to food and shelter is not okay. I was also incarcerated at 20. Spent over 3 years at Garner Correctional Institution. That's over 1,300 days in maximum prison. And this was between January 2019 to 2022. not only coming home to a world coming out of a pandemic, I came home to nothing but my mom and my family. No housing, no proper introduction into Demas, nothing. I'm still struggling with understanding how I spent that much time in an institution to come home to no home. When at 20, I had my own apartment thanks to connections. Shout out Orlando. My point is, homelessness is at a high, especially for felons like me who can't find a landlord that accepts us, let alone even having the ability to get a job to get shelter. I have schizophrenia and manic depression and can barely find a Section 8 application that will take me to Hartford. I have hope that things will get better, but I'm not going to sit back and watch. I had to come here and let you, our representatives, know what is happening in our state with your constituents. There are people still filling up House of Bread. There are lines on Church Street for 2 sandwiches and a water bottle um, out in the cold. If you just go outside, you can see everything you need to. Now, how do we fix the problem? I'm here to support bill number 6948. There's many ways this bill could help poverty and record homelessness. This bill increases housing access, preventing landlords from considering certain past convictions, allow more people to secure stable housing, and reduce homelessness. It also supports rehabilitation and reintegration, reduces the revolving door, as we say. Studies show that access to stable housing decreases the likelihood of reoffending, making communities safer in the long run. Promotes fairness and second chances, decreases discriminatory practices. There's also economic benefits. With stable housing, individuals are more likely to find and maintain employment, reducing reliance on public assistance programs and contributing to the economy. Now, there's ways to strengthen this bill also. Clear guidelines on eligible convictions. I feel like, honestly, there's so many convictions that are innocent. Like there's a lot of people that cop out to certain things in this state, not because they're guilty, but because they want to go home. And I feel like we have to take that into perspective that half of the people that have been incarcerated, have felonies out here, didn't do the crime. They just did the time. So that's something we should put into perspective.
Mr. Brown, your 3 minutes have expired. If you can please summarize. Thank you.
Sorry. To summarize, basically, we could also support for landlords, provide incentives for landlords to rent to individuals with criminal records, such as tax credits or access to state-backed rental insurance programs, offer screening tools, access tenants, reliability beyond just criminal history, strengthen tenant accountability measures, and implement a probationary period or structured lease agreements where tenant demonstrates stability and good behavior, allow landlords to consider criminal records only if they pose a direct risk to the safety of other tenants, expanding housing resources, public awareness, and education on everything could help a lot.
Thank you, Mr. Brown, for sharing your personal story. Yep, Rep. Turco.
Thank you, Madam Chair. I just wanted to say one thing. I mean, you sat down here and you called us rock stars for being here for almost midnight. You're the rock star. I mean, for everything that you've overcome and everything that you're doing, and that you're here to advocate for yourself and for people that have gone through experience like you've gone through and help make positive change in the state. You're the rock star. So thank you so much for being here.
Thank you.
Thank you, Madam Chair.
Okay, seeing no more questions, drive safely. Next we have 97, Lynn Haig, followed by Sam Pappas. So Lynn, online, please go forward. If you are, I know, 99 to 109, because 109's here, you should get on quickly. Okay, go right ahead, Ms. Haig.
Good evening, Co-Chair Representative Felipe and Co-Chair Senator Marks and members of the Housing Committee. My name is Lynn Haig. I am a homeowner in Oxford and involved with All In for Oxford. I am speaking in favor of HB 6889, and act concerning evictions for cause. My college-age son will soon be looking for an apartment, and I work with many folks who rent. I also anticipate that I'll be downsizing in the next few years and potentially becoming a renter. So despite me currently being a homeowner, this issue is important to me because it directly impacts many people I care deeply about. Connecticut currently has just cause eviction controls in place, as we've heard a lot today, for persons over the age of 62 who live in a 5-unit or larger building. This bill, quite simply, expands the targeted group to include all ages. Nothing else changes. It's really that simple. Have you heard of landlord outcry because they were unable to evict older tenants? I haven't, which tells me that the existing just cause eviction parameters are working fine. We've also heard that a few times today. Landlords who own buildings of more than 5 units are typically investors and corporations. They hire property management firms to maintain and lease the building. Some operate in a respectable manner and others not so much. It's the not so respectable landlords that will be opposed to this bill because they will have to make decisions based on documented evidence, not on a whim. More and more Connecticut towns and cities are seeing larger apartment buildings purchased by out-of-state companies. We heard a lot of that today. They are immediately raising the rent significantly. This is forcing many tenants abruptly into an inhospitable housing market that they likely were not prepared to enter because their housing situation was stable, until it suddenly wasn't. Significant rent increases do not qualify as an eviction for cause. This bill is not about removing landlord rights. If a tenant doesn't pay rent, commits a crime, or destroys the unit, the landlord currently has and will continue to have every right to terminate that lease. Housing stability and transparency is what this bill is trying to achieve. It is expanding the protection that seniors currently have and giving it to the general population. Housing stability is important for my colleagues, friends, and soon my son. It is also important to me as a human to see that everyone has housing stability. For these reasons, I strongly support passage of HB 6889 and act concerning evictions for cause. Thank you for your time and attention.
Thank you, Ms. Haig. Seeing no questions, we will go next to Sam Pappas, followed by Terry Ricks.
Hey, everybody. How we doing?
Good, go right ahead, sir.
Cool. Please support HB 6889. Can I actually stand in the middle? I've
No,
always
you-
wanted to
nope.
stand in the middle.
No, you can't. But please just state your name and where you're from.
Oh, I'm
And
standing.
then just speak into the microphone so everybody online
Yes.
can hear you.
Yeah. Yeah, what she said, what they all said. You guys already heard all the good arguments. I got nothing to add. Just happy to be here. Shout out to everybody supporting unhoused people. It's messed up to take away anyone's housing. So everybody deserves housing. That's it. All right, bye.
All right, thank you, Mr. Ricks. Oh, no, that was not Mr. Ricks. That was Mr. Pappas. And then next, Terry Ricks, followed by Lucy Autumn Song.
Good evening.
We hear you, Ms. Ricks.
You hear? Okay. Hello, Senator Marks, Representative Philippe, and all the distinguished members, kings and queens of the Housing Committee. My name is Terry Ricks. I am a lifelong resident of Hartford and a smart justice leader with the ACLU of Connecticut. I am a person who has been directly affected by homelessness due to housing challenges. I am 100% disabled. and I am 61 years old. I am an individual who have been speaking and fighting for change even when I lived for 3.5 years in a hotel due to housing challenges. Every day have been a fight, but nothing have been as tough of a fight as being freed from prison in 2005. After completing changing my life, housing has consistently been a problem that even eludes me to this day. I am here strongly asking for your support for HB 6948 and that concerning collateral consequences for criminal records of housing opportunities. One of the most challenging and difficult obstacles that people face is housing discrimination. No matter how many years you have gone by, no matter how qualified a person may be, no matter if you have good or bad credit, people should never be denied a place to build a foundation to be creating and thriving part of their community. This makes individuals who have rebuilt their lives feel that the door continues to be slammed in their face, giving us opportunities to people who have done their time and paid their debts to society, have continued to show positive growth since they've been home, should have a right, not the luck of the draw, in giving people the opportunity. Not always is a risk proposition, nor is it a favor from anyone. It is a unified right. The risk falls within not allowing people to have a second opportunity at interrogating or back into their communities. Excuse me. And show that they can be law-abiding citizens. This act began the process of helping individuals find safe and secure housing. I've been in the fight for survival, but it's not about me. I'm in this fight to save lives. HB 6948 is about the fight for survival for each and everyone affected by collateral consequences of living with a criminal record. So once again, I respectfully and urge the members of the Housing Committee to support HB 6948 to give people who are doing the right thing a true opportunity, such as me. Thank you for listening to my testimony, and I welcome any questions you may have.
Thank you, Ms. Ricks. Chair Felipe.
Thank you. I want to make it very quick. I know we see you every day. I just want to say thank you for your energy, and I wish there was a Terry Ricks and about 100 more speakers, just so we could have something to look forward to. So thank you very much.
I appreciate it. I love doing what I do. You know, this not a job, it's a way of life for me, you know.
Thank you, Ms. Ricks, and for doing the right thing. Seeing no more questions, we are going to go to Lucy Autumn Song, followed by 109, Jennifer Lino. Autumn, Lucy, welcome.
Hello, and thank you to the co-chairs, Senator Marks and Representative Felipe. As a member of, and as well as members of the committee, my name is Lucy Autumn Song, and I am speaking today in support of HB 6889, which would protect tenants from arbitrary lapse of time evictions. As a tenant, I was hesitant to even testify today, out of fear that I could be legally retaliated against for speaking out. And it's the fact that landlords have the power to legally take someone's home away from them for political speech or organization that they disapprove of is terrifying, and it's wrong. Even though I'm doing everything right, I always pay my rent on time, I'm a good neighbor, and I'm a hardworking member of my community. I could be doing all that right, but by speaking here today, I am putting my livelihood in someone else's hands. I'm at their mercy, basically. And my wife asked me not to speak today because she was really worried. And I am nervous, but it's important that our voices are heard. And as well as a tenant, I am also a trans woman
And in Connecticut, it is illegal for landlords to discriminate against us or other marginalized groups because of our membership in those groups. And I love that about Connecticut. But no-fault evictions make it very easy to undermine its protection because they can just say it was for no reason. And I think it was Mars who gave the example that someone could transition before the landlord knows, and then the landlord later finds out and then evicts them because of that, but really it's no fault. And my community is under attack at the federal level. People are scared, and I feel like we need Connecticut to continue being safe for us, and that starts with keeping us in our homes. And I want to say none of this is a personal complaint towards my specific landlord. Rather, I'm speaking more broadly about the vast power imbalance that landlords have over tenants, whether they choose to weaponize it or not. Like, we know there are good landlords who are responsible and don't do this, but the very fact that they have this power presents a really powerful imbalance of power. And I want to say this is not a liberal versus conservative issue. This is about protecting hardworking people from abuse of power by landlords. And something I want to comment on is I told some of my conservative family members about this bill, and we don't, trust me, we don't agree on pretty much anything, but they were supporting this bill. So this is a very popular bill across the board, and it appeals to people, it appeals to a lot of people. So I asked the legislature to please be bold, please be confident in yourself, and please pass HB 6889. Thank you. I appreciate all of you for taking the time to listen to us.
Thank you so much, Lucy. Seeing no questions, thank you for sharing your story and for being brave. Next we have, no. (102) Christopher Duza, are you there? Okay, I did say, so Christopher, I did say Jennifer Lino was next because she had been waiting. So I'm going to let Jennifer go, and then I'll let you go after our next in-person.
Okay.
Jennifer. We can't hear you, Jennifer. If you can unmute.
Hello, can you hear me?
Yep, now we can.
Okay. Thank you, co-chairs, Representative Felipe, Senator Marks.
Oh, shit.
Ranking members, Representative Scott, Senator Sampson, members of the committee. Thank you for the opportunity to provide my testimony on the following bill. My name is Jennifer Lino. I'm here today to testify against HB number 6.
Jennifer, we're having a little bit hard time hearing you. Could you get a little closer to the microphone?
Yes. My name is Jennifer Lino. I'm here today to testify against bill number 6889, an act concerning evictions for cause. I come from a background of property managers deeply committed to providing residents with good quality and stable housing. When we welcome a new tenant, we carefully go over rules and policies. The leases we sign with our tenants clearly outline these expectations, ensuring everyone understands their responsibilities. Over time, we have encountered situations where residents have not upheld their part of the bargain, including inconsistent late payments, overstaying beyond the end of the original lease term, becoming squatters, and even posing threats to other neighbors. In one instance, a tenant's disruptive behavior not only violated the lease, but also created an unsafe environment for other residents, forcing us to take swift action to protect the community. When these actions arise, housing providers need the ability to be able to quickly remedy the situation and maintain safety, as well as the well-being of the community. We know that neighbors often hesitate to testify against each other due to fear of retaliation, and that's why it's essential to ensure that landlords have the option to address these issues effectively. Thank you for hearing my testimony.
Thank you, Jennifer, for your testimony. Any committee members have any questions? Okay, seeing none, we're going to go in person to Morgan Miller. I don't see Morgan. So we will go to number 102 online. Christopher Dews. Dews? Go right ahead, sir.
Good evening, Senator Marks, Representative Felipe, ranking members, Senator Sampson, Representative Scott, and all distinguished members of the Housing Committee. My name is Christopher Dews. I'm a resident of Bridgeport, a father, ACLU Smart Justice. I'm with ACLU Smart Justice in support of HB 6948, an act concerning the collateral consequences of criminal records on housing opportunities. With respect to HB 6948, I can attest to the factual evidence that housing is a basic human right. From my experience and from many and many others whose voices have been silenced due to shame, guilt, and humiliation, we have been stripped of a fundamental component of human dignity. The challenges that a person with prior justice system involvement in Connecticut is equivalent to the story of Lot's wife in Genesis 19. She was told not to look back because if she does, she will be turned into stone. Thousands of Connecticut prior justice system offenders have been turned into stone due to somebody simply looking back. And what did they see when they looked back? They saw a past that a prior justice system offender is trying to escape from. A past that absolutely cannot remain in its place in space and time, simply because it's pulled into our present time while searching for a habitable, adequate space for protection from the elements. In particular, my experience has varied while dealing with housing. I was lucky enough to have a supportive family and friend structure upon my release from prison 2015. But the times when I did have my background verified, I ran into issues, particularly with my criminal history. While flat out being denied by one landlord and told there were reservations on me moving in due to my history by another. The insurmountable pain of the rejection the insurmountable pain of the rejection is a feeling that words cannot convey. HB 948 has the potential to break our people from the stone structures and help bring a sense of peace to the downtrodden. Thank you for taking time for listening to my voice and our voice. I'm happy to answer any questions.
Thank you, Mr. Dews. Seeing no questions, we will go to our next. I only have two more in-person people, Paul Boudreau and Ivalise Brown. So if anybody else is in person that has not testified, please go to our clerk, Sakaitis, and Mr. Boudreau, welcome.
First of all, thank you all for staying the distance with us all. I know these are long, long nights. I've done a few of them now. My name is Paul Boudreau. I'm from Hamden, and I'm the president of the Hamden Tenant Union. I don't think I've ever actually read the written testimony I've made, because by the time I get up here, I have something completely different to say. To start off with, they tried to evict me on a serious nuisance. Serious nuisance is only 11% of the actual evictions in Connecticut. They're very hard to prove. They're for criminals. And if we're supposed to believe that 11% of our tenants are criminals and that all these are legitimate, and then they're saying a lot of them are converted. So maybe that's 15%. So we're saying 15% of our tenants are criminals. In reality, these things are used as retaliation. And the way I got mine is we started a tenant union because we didn't have maintenance, management, landlord, or anybody for 6 months through COVID. We had a mailbox to put a check in. We paid our rent every month. Landlord came back, towed our cars, and when we complained to the city, we got a lapse of time eviction. We convinced the landlord that we changed our mind and that we weren't going to do tenant union anymore. Then they gave us a lease. Then the next week we did an action as a tenant union. And then the week after that, they filed a serious nuisance eviction against us. As a tenant union organizer that's organized all over Connecticut, I can guarantee you these are used as retaliation. And lapse of time is used as retaliation. They'll use any method they have. Taking our cars as retaliation. You know, everybody says property is sacred unless it's our property. Ultimately, if we don't pass this, we're going to have a crisis on our hands at this point. We're already 13% up on homelessness. I've seen people going out. I've lived in my car. I was also thrown out. My first eviction, I ended up living in my car in February. It's no fun. And I was lucky. I only had to do it for a month. I know people out there have been out there for years, because of something silly like their car got towed, then they couldn't get to work, then they couldn't pay their rent. And now they're living on the street. Some of them have died. A lot of people are going to die out there. I'm not trying to be overly dramatic. This is the truth. I've seen it. I started with homeless outreach and then just kind of fell into tenant organizing. But this is a very serious problem. There is water coming through a lot of people's roofs, and I've literally seen it. I didn't make these, like, I didn't come here with like fake people. I can provide anybody you want with testimony, with actual facts and figures, with case numbers, even, you know, even court cases, and give you the specifics as opposed to just saying off the top of my head and I think it's this in my firm. But we can't use those numbers to base our decisions on because they're not the real numbers.
Expired. If you can please summarize.
Sure, thank you. We have to base this stuff on reality. You know, again, everything's sacred until it's ours. Our house, yeah, their housing sacred, their property sacred, but unless it's ours, and then it's not. Then it's just a contract. It's profit, and again, profit is, you know, profit is what really is sacred to all these people. It's not about being a housing provider. Mark Coville at Amistad House is a housing provider providing tiny homes in his yard for free. Everybody else is a landlord. That's what we call them. We can whitewash it however we want. Thank you. Sorry for going over.
Thank you for your testimony. Any questions? Thank you, sir.
I'm sorry.
No, that's okay. Next, we will have 111, Patrick Thompson. And if you are online and you still wish to testify, we only have 111 and 112 online. So if you are in those low 100s, I would get on pretty soon. Go right ahead, Patrick Thompson.
Hello, I wanted to thank the Housing Committee for hearing my testimony. I really appreciate all your time and hard work. I know it's a late night. My name is Patrick Thompson. I'm an HVAC technician. I work in the state of Connecticut, a part of the local 777 Plumbers and Pipe Fitters Union. I'm also a DTC member and a town constable for the town of New Britain. I like to see myself as a pretty active member of my community. And in the year of 2023, I was living in the very, very big complex Pebblebrook Apartments in New Britain. I had an issue where my roommate was unemployed at the time, and for 3 consecutive years, they increased the rent for about $100. I decided that I couldn't afford the rent increase, and I wanted to negotiate a price, and I filed a complaint to the Fair Rent Commission. And I immediately, as soon as I filed a complaint to the Fair Rent Commission, they retaliated by not renewing my lease, which is retaliation. They said that there's no options. We don't want to renew your lease. They sent lawyer to represent them from New York. That's where the owners of Pebblebrook Apartments are from. They're not a CT mom pop landlord. They are a big multinational or national company that literally has thousands of properties across the country. I thought that, I support HB 6889 just because it gives people to want to fight against these big corporations, the big corporate landlords, a chance and a foot at the table to negotiate. I'm working as a full-time HVAC technician, and I can't keep up with the rent, and I got evicted. Basically, they gave me 6 months to leave, and I left. You know, and it's very unfortunate that I was forced out of my home, and I feel like, you know, as someone who commits so hard for the community, I deserve a place in my home and not be retaliated and forced out of my home. So that's my story and why I support HB 6889. And thank you guys very much. I really appreciate it, and I hope you all have a great night.
Thank you, Mr. Thompson. Seeing no questions, we will go to our last in-person testifier, and that is Ivelisse Brown.
Thank you for the committee for allowing me to speak today. To answer a previous question from Senator Sampson, most
Ivelisse, can you just state your name and where you're from?
Ivelisse Correa Bela Matixo. So to answer a previous question from Senator Sampson, most mom and pop landlords are happy to have a steady tenant. The only time I've ever seen them actually evict has been due to the breakdown of a relationship, like due to lack of payment or damage to the unit. Sometimes it's because of retaliation due to making a complaint on the landlord. Courts are overrepresented by tenants who many times made a complaint. This makes HB 6889 for just cause evictions a necessity. And to address another statement previously made, about 25% of all new purchases in Connecticut are corporate landlords, and this has been the case for several years. SB 1303, an act concerning non-resident landlord registration and increasing penalties for repeat building and fire code violations. Hartford and every other major city in Connecticut has dealt with out-of-state slumlords with a bunch of properties for years. Registration is a step in the right direction, but will not solve the problem alone. Hit them where it hurts financially. Hartford's Gray Hill Group Management from Hartford's recent fire used to be Avalon Village, used to be Maple Group Management, and will probably become another LLC in a few months. Connecticut is one of the most segregated states in the union due to federal housing policy. Let's keep our Black, brown, and low-income residents safe. HB 6939, funding for right to counsel. There isn't enough funding for this program. Not everyone who needs a lawyer has had access to one in court, and it was my understanding that people would have lawyers in court in the eviction proceedings I've seen, but that has not been the case. Please fund this program. HB 6947, an act prohibiting residential pricing algorithms. Our Attorney General is alleging in court as part of a multi-state lawsuit with the Justice Department that pricing algorithms prioritize profits and will do so by raising rates and restricting housing stock. Please ban this. HB 6946, annual reporting of housing authorities. The state should see how much is paid in overhead and costs. Vouchers should be state or county-wide in order to save money on payroll and overhead, and those savings should go into vouchers and security deposit assistance. So it goes without saying that I also support SB 6938. HB 6948, an act concerning collateral consequences on criminal records and housing opportunities. I support this bill because people should be housed after they serve their time. The terms proposed are reasonable and would assist with preventing recidivism. This bill would be restorative justice for the Black and brown community, and I feel it is a step in the right direction. I will summarize. I do not believe this bill is perfect, but I do believe it's life-changing and overdue. The entire record is not sealed. Sexually violent offenses and murders are not included, so the fear-mongering should end. The rent is so high in Connecticut. We are the only fans creator capital in the U.S., proving that we're doing so little in Connecticut to prevent homelessness. In our state, you need a job, a side hustle, and a side of cheeks. Thank you to the committee for allowing me to speak today. I'm happy to answer any questions, especially from Senator Sampson. The Property Owner Defense League is definitely getting their money's worth for their donation with him. Thank you.
Thank you, Ivelisse, and seeing no questions, we appreciate your time and your patience. Next, we are going to go to 111, Mary Valavinos, and then after that will be 127. No, excuse me, 126 and 127. So, oh,
Madam Chair, just very quickly before we go on, just for folks on Zoom who are not accepting their promotion to panelists, if you do not accept your promotion, we cannot let you speak. Because we have some lower numbers that are not accepting their promotion, that's all.
okay. Go right ahead, Ms. Valdivinos.
Thank you very much. Good evening, Representative Felipe, Senator Marks, Ranking Members Sampson and Scott, and esteemed Housing Committee members. Thank you in advance for your time and dedication to the matters at hand today. I know it's late and I'll try to keep it brief. My name is Mary Valdivinos. I am a resident of Norwalk, Connecticut, and a member of various social justice organizations within and outside of the state. I'm here in strong support of House Bill 6948, which ensures a fair, balanced approach to housing by addressing barriers faced by individuals with criminal records, while also respecting landlords' rights. In Connecticut, approximately 1 in 3 adults has a criminal record. Stable housing reduces recidivism by up to 50%, improving public safety and economic stability. Yet, nearly 80% of formerly incarcerated individuals have been denied housing and are up to 13 times more likely to experience homelessness. This bill does not eliminate criminal background checks. Instead, it ensures fair and case-by-case evaluations by delaying background checks until after a conditional housing offer, limiting consideration to specific convictions based on severity and time elapsed, requiring an individualized review, allowing applicants to present evidence of rehabilitation, protecting landlords from liability when renting to individuals with records. As someone with a criminal record myself, I have personally struggled to find housing despite working 3 jobs, maintaining a great credit score, and being financially stable. Despite successfully turning my life around, I continue to face rejections solely because of my past, while landlords and real estate agents alike push me towards settling for subpar housing options. This is unfair. In my work as a case manager for individuals impacted by gun violence in the state, I see my clients forced into unsafe housing because they cannot pass these background checks, even when they have the means to pay. House Bill 6948 is fair to both landlords and tenants. It establishes a clear, consistent process for making informed rental decisions while respecting property owners' rights. Similar laws have already worked successfully in New Jersey, Chicago, and San Francisco. Connecticut voters overwhelmingly support this approach, with 74% in favor of reducing housing discrimination based on criminal history. The majority believe that people who have served their time deserve a chance to rebuild and contribute to society. I urge this committee to support House Bill 6948 to create a more just, safe, and inclusive Connecticut. Thank you for your time and consideration.
Thank you, Ms. Valdivinas. Seeing no questions, we appreciate your testimony. Next, we will go to 125, which is Christina Capitan.
Hi, everybody. Can you hear me?
Yes, we can.
Good evening, Senator Marks, Ranking Members Sampson and Scott, and honorable members of the Housing Committee. My name is Christina Capitan. I'm a resident of Broadbrook. I represent the CT Canna Warriors, a grassroots cannabis advocacy organization here in Connecticut. I'm here to strongly support the passage of HB 6948, an act concerning collateral consequences of criminal records on housing opportunities, as I believe this is a step in the right direction to prevent unjust housing denials for individuals with criminal records, including those with past or current felony charges for nonviolent cannabis offenses. Especially important now as our governor and attorney general place heavier emphasis on enforcement of cannabis use outside of our regulated adult use market and our failing medical cannabis program, leaving patients at great risk. This may come as a surprise to some, but in the state of Connecticut, people continue to face arrests and as a result, severe consequences for nonviolent cannabis offenses. A recent case involved an individual that was arrested in Waterbury for possessing 6 ounces of cannabis that was stored improperly and $40 in his vehicle, which led to him facing 2 felony charges that sat on his searchable record and in the news for 3 months until it was resolved in February, likely resulting in probation. I'd imagine that individuals like him may struggle with housing insecurity or be subject to loss of housing due to these charges for a relatively minor offense that will likely be removed from their records after completion of a court-mandated program or probationary period. HB 6948 is a step toward ensuring that individuals' past do not dictate their futures and that their present legal issues do not get compounded with additional issues with their housing security. Because of unfair prejudice and lack of education by housing providers regarding cannabis laws, as well as its many medical benefits. I'm sorry, it's late. Its many medical benefits. I implore you to pass this bill to work toward a more just and inclusive housing system for all persons in Connecticut. Furthermore, to summarize, I urge support for 6889 as well, an act concerning evictions for cause. And I'd just like to quickly remind everyone that in Connecticut, medical cannabis patients can and often do face discrimination in housing situations, mostly due to the stigma surrounding cannabis use and the odor associated with it. Even when they are using it within the provisions of their leases and lawfully without legal protections addressing these issues, patients and others who face bias due to racism and disabilities or for any other reason will remain vulnerable to unfair treatment, making it difficult for them to secure stable housing for themselves and their families. Thank you very much for your time.
Thank you, Ms. Capitan. Any questions? Seeing none, much appreciated. Next, we have 126, Kian Worth.
Yes, good morning. Honorable Senator Marks, Honorable Representative Felipe, and distinguished members of the House Committee. My name is Kian Worth from Canton, and I am a homeowner. I strongly support House Bill 6889, an act concerning evictions for cause because it addresses a critical gap in tenant protections by providing a remedy for cure. With my background in business law and economics, holding an MBA and a JD, I respectfully respond to Senator Sampson's comments comparing this important issue solely on contracting laws, free market dynamics, and hedge funds for profit. The reality is that this isn't a pure free market situation. It's a controlled system that leaves our most vulnerable residents at a disadvantage. And this is a large systemic problem. In the 1776, Adam Smith, the renowned economist, introduced this concept of supply and demand in his work, The Wealth of Nations. His analysis implicitly includes the ideas of substitution when prices rise, while Senator Sampson suggested that, like milk and eggs, consumers can simply switch to alternatives. When housing is a fundamentally different, unlike food, there is no viable alternative to safe and stable housing. Then later, and around that similar time, the French introduced the laissez-faire, meaning that the government hands off. Unfortunately, in 1789, there is a French Revolution. So currently in France, the government banned any evictions during winter times. So this imbalance starkly illustrates that housing cannot be treated merely as a commodity. Just as Connecticut regulates essential utility through PURA to protect consumers, housing being equally vital requires similar safeguards. Without secure housing, individuals cannot sustain employment, maintain their health, and pursue education. I'll be quick. Housing is not just another market goods, it's a fundamental necessity. Moreover, tenants contribute significantly to our communities. They pay rent, support property upkeep, and invest in neighborhoods stability. This financial and social contribution creates an equitable right to housing protections. It is not a matter of undermining property rights or destroying the rental market. It is about ensuring fairness and stability. Finally, this is a matter of justice and equity. Housing insecurity disproportionately affect low-income families, seniors, and marginalized communities. We have a social and moral responsibilities to protect the vulnerable and ensure that every Connecticut resident has access to safe, affordable housing. Furthermore, in contrast, housing providers imply
your 3 minutes is up, ma'am, or can you please?
Yes, I'll be good. Last sentence.
Can you please
Yes.
wrap up?
Yes, thank you, Madam. Furthermore, in contrast, housing providers imply a broader role that goes beyond ownership. They have a responsibility to offer safe, stable, and affordable housing. This role carries an ethical and social obligation.
I'm gonna stop you because your 3 minutes was up probably 3 minutes ago. And
Okay, thank you so much for your time. Yes, thank you so much for your time.
Ranking Member Sampson has a question.
Okay.
Thank you, Madam Chairman. Welcome, Kian. I just wanted to respond because you mentioned my name a few times, and I think you attributed some commentary to me that I don't think I said, but that's besides the point. Are you suggesting that the state of Connecticut should develop a way to regulate housing similar to the way PURA regulates our utilities? I'm asking because I don't think PURA has done a very good job of keeping our electric rates down, nor has the majority that dictates the energy policy in the state, who we are leaving in the hands, their hands right this moment in this discussion about housing policy. Through you, Madam Chairman.
Okay, yeah. I'm not suggesting anything one way or the other. I'm only comparing how when consumers run into certain issues with public utilities, at least there's a place for them to turn to and hopefully to negotiate or to find solutions to resolve their dilemmas, where housing, certainly utility is part of that housing necessity. So I'm not saying that to counter that the property owners do not have rights. You know, they do have rights. However, I just felt that we should not look at this particular bill in a very narrow point of view to simply look at them as a owner's rights or the tenant's rights. However, to merely provide some sort of a alternative for some sort of an amicable resolution for, you know, just for a remedy, for cure, all of the, you know, the greater goods. That's my point.
Thank you, Ms. Worth. Ranking Member Sampson.
Thank you, Madam Chairman. I appreciate your comments, Kian. I would just Free me, I got distracted listening to what you said. I'll just, I remember now. It's I just have to disagree. I mean, you know, if you complain about your electric bill to Pura, it's going to go in some email thing and be lost forever. I mean, if you have an issue with your landlord or your housing provider, which I don't think is a PC term, I think it's just an appropriate term. You have lots of options. I mean, just frankly, and I'm not defending landlords, but you have the housing court, you have fair rent commissions, you have government paid legal aid currently, something the landlord doesn't have, and you also have civil litigation. I mean, these are avenues that work in almost every other industry. You also have the ability to negotiate a contract, you know, which I pointed out several times today when people said the landlord writes the contract. I'm like, well, we go through life signing contracts that we don't have any say in at all, like cell phones, cars, you name it.
Absolutely.
Yeah. So, you know, I'm again, I have one question for you, and it's the same question I've asked a lot of people, which is this bill has to do with one thing, which is people that overstay their lease. The lease ends on a specific day, and this is an issue. This bill basically says people are now going to be allowed to overstay their lease, and the landlord only has one option now to reclaim their property, and that is an eviction, which is a very costly process. You know, it used to be under current law, people are expected to leave when the lease ends. And of course, there's supposed to be a negotiation at a time about what, you know, and notice and all that. But now we've only changed it to just there's an eviction. And now we've also limited to certain reasons for that eviction. And I pointed out several that I think are very reasonable, like a landlord wanting to use the property for a relative at the end of the lease. They will not be allowed to. In fact, they would fail at an eviction. So I guess my question is, how long should somebody be allowed to stay in another person's property beyond the agreed to lease date, lease expiration? I guess that's the end of the question. Question mark.
Yes. Yes. Senator Sampson, with all due respect, I hear that question from you so many times since this morning. And to be honest with you, I'm really not in the position to offer any answers because I believe that these are the substantive elements that for the lawmakers such as yourself for consideration. And even if we were to bring this matter into the court session, the end result may be bouncing back to the legislature's intent as to how long being reasonable or not being reasonable. Now, as far as the utilities with Pura, for example, I believe that if you know, a Connecticut residents, if they're facing some financial hardship paying their bills, I believe that there's certain supplement or certain assistance helping them to get through that hardship. So where we're looking at here, that as your question imposed as to how long that is being reasonable, that really is subjective from landlords to landlords, such as yourself, that based on the tenant's needs as to how to resolve coming up to an amicable resolution. But here in this bill, we don't see that alternative or that assistance. Rather than defining the length of the time where the tenant entitled or landlords should provide, maybe there's some alternatives as to what is the assistance there from this bill to resolve at some point in time where will not drag the landlords into the court system and will not jeopardize the tenants' well-being to sustain their livelihood. Nothing is perfect, truly. I mean, you made a very good arguments. I mean, you should be a lawyer. I'm sure you're you will be a very well-known lawyers. But there's some elements that the court simply cannot just make judgment or ruling and saying that this is the way it's supposed to be, even with the best intent from the legislature. And I think that what is not perfect, perhaps, that this bill may be able to offer something, maybe not in the totality, but perhaps from a humanitarian perspective, offer something to really for the greater goods, Your
Thank you,
Honor.
Ms. Worth. Thank you. Attorney Sampson?
Thank you, Madam Chairman. As discussed, I am not an attorney. And
You would be
but
a
I
great
do
one.
appreciate the compliment that I made a good argument. I don't want to prolong our conversation, but I will say that there is a lot of assistance that is provided by the state of Connecticut. I mean, there's $400 million are spent every year in housing assistance. You have Section 8 vouchers. You have, various other programs in addition to legal aid, and also programs that help the poor generally that would be beneficial. The question I asked was, how long beyond the date that the tenant actually agreed to should they be allowed to use someone else's property? That's the question. And the bill is indefinite. It's forever, effectively. That's how long their right to the housing, quote unquote, would endure. And I find that, some folks have tried to make a moral argument that somehow it's abusive of a landlord to want to reclaim their property at the end of a lease. And I say, the other side of the moral argument is, it's like, how long should you deprive someone of their own property? That this bill is not written in a way that is reasonable for either party. There are solutions that we can come up with that will help tenants that are faced with difficult situations. And there are undoubtedly bad tenants and bad landlords in the world, and we should protect both parties from one another as much as we can. But we shouldn't write a terrible and crappy bill, in my opinion, that is one-sided, that does not come up with a real solution. I could probably ask you 100 more questions, Kian. You're delightful to speak with, but we'll let since we want to get to so many other folks, and it is late.
Sure, of course.
But I appreciate the conversation.
Yeah,
Okay,
and thank you so
Ms.
much.
Ian,
Thank you.
Ms. Worth, yep, we're good. There was no question there for you, and we appreciate your testimony. So moving forward, we're going to go with Z. Rubin, then Robin Ledbetter, and then Ramidi Sharif. I ask all those out there, if you are, please accept your panelist promotion. We are up to 129, and then nobody else is on. So everybody, it's cold. I guess everybody's sleeping. So next we have, we have somebody. Oh, we have 32 more people on. Okay, Z. Rubin.
Hi, can you hear me okay? Can you hear me?
Yes, thank you.
Okay.
And we do have 32 more people on, so I was just
Thank you, thank you.
I didn't know how to use Zoom. Go right ahead.
Okay, thank you. My name is Z. Rubin. I've been a tenant living in Hartford for over 7 years. I would like to voice my support for HB 6889. I'm here even though I'm not protected by just cause as a tenant of a 2-unit house. I love where I live. I love my community that I'm privileged enough to be a part of. I share my apartment with my partner, Jenny, along with 2 other roommates, and a cumbersome collection of houseplants. I firstly want to counter the notion that landlords and real estate developers deserve the self-appointed title of community builders as housing providers. To be perfectly clear, our community builders are activists, gardeners, artists, musicians, and the queer couple that lives with their pet cat. Most landlords are simply just capitalists seeking to expand their portfolio off the backs of the working class. As for my personal experience, my household does not have a lease. We exist on an intangible month-to-month lease that leaves us in a very vulnerable position. Following my numerous requests to write us an updated lease, our landlord finally sent us a lease with a rental increase. That was nice of them, along with a sneaky clause that granted them the right to charge a nondescript fee at will to cover unexpected expenses. In response, I attempted to negotiate, as Rob Sampson proposed, and we agreed to sign the lease and the rental increase under the condition that the unexpected expense clause was removed. To this, I was met with silence and avoidance. This was the end of any negotiation and has left us still without a lease, one that we will likely never receive in fear of retaliation for even trying to negotiate. To make matters worse, the law office that my landlord uses is actually right next door to my house. So I get to see it every single day when I think about speaking up about my rights. In my 7+ years living in this apartment, I have always tried lightly and bent over backwards to ensure that I give my landlords no justification or motivation to evict us. Our rent is always paid on time. We take excellent care of our property. We're in consistent communication with the landlords, or we attempt to report any concerns or maintenance requests that are often ignored by them. Despite all this effort to appease our landlords, we are still at perpetual risk of losing our shelter. I have known in my entirety of living here that tomorrow my life, the lives of my housemates, and my community could be uprooted with no just cause. Regardless of how I've conducted myself as a responsible tenant, tomorrow I could be evicted without warning and without causation. Even me speaking here today brings with it the risk of retaliation from my landlord as I advocate for a change to tenant rights. I am hopeful that if they were to hear about my presence here today, it would not concern them. But simply, that's the issue at hand. Is my participation in the legislative public hearing grounds for me to be evicted? Should my landlords have total domain over my day-to-day existence? And should I exist with trepidation and hopes that my housing is secure tomorrow? Today, you have heard testimony from countless speakers who are in even more vulnerable positions than myself. I acknowledge my privilege here and acknowledge that there are folks whose circumstances and experiences with housing are truly dire. I'm here to show my solidarity and support with every single renter in Connecticut. I strongly support HB 6889, and I support any bill that ensures housing for all human beings. And I see Senator Sampson's hand is raised. I will refuse any questions he has. I don't want him to waste any more time. Thank you.
Thank you, Z. Ranking Member Sampson.
I'm going to leave now. I'm not going to answer any questions. Thank you.
What happened? Oh, sorry, Ranking Member Sampson. Next we have Robin Ledbetter.
Oh, hold on. Okay. Good evening or good morning. Hello, Senator Marks, Representative Felipe, Ranking Member Senator Sampson, Representative Scott, and the distinguished members of the Housing Committee. My name is Robin Ledbetter, and I am a resident of Hartford. I am a member of the ACLU Smart Justice, and I am here to testify in support of House Bill 6948, an act concerning the collateral consequence of criminal record or housing opportunities. I am formerly incarcerated after entering a correctional facility when I was just 14 years old. After reintegrating back into my community after serving 25 years, housing was the biggest obstacle that I faced. Although I worked a full-time job since the third week of my release, have consulted and worked with several prestigious schools and organizations, and was willing to pay up to 6 months rent in advance, no landlord was willing to take the chance on me as a tenant. I faced homelessness, sleeping in my friend's basement, and hotels. The facts are, Black women experience the highest rate of shelter homelessness, almost 4 times more than white men and 2 times more than Black men. Desperate, I had something few people had, someone who had absolute trust in me, my mother. So I had to ask my 76-year-old mother to take responsibility for a 40-something-year-old me, when I should be independent. She co-signed an apartment so that I will have somewhere to live. In the 3+ years I've lived here, I have never been late on my rent. I've never had a complaint. I've had good relationships with my neighbors. I feel really blessed. I feel that my building is safe, it's clean, and I do enjoy where I live. I am engaged, as I was last year, and ready to conquer the next milestone in my life. But my fiance, who is also formerly incarcerated, because of my fiance is also formerly incarcerated, we have maintained separate addresses. I have not been able to plan or even think about my wedding because I will have to leave the place where I love and built for myself. Last year, I shared my testimony and I was looking for an apartment for myself and my fiance could rent together. I have visited several properties, but even with a job, good credit, and a spotless record where I live, not one landlord was willing to rent to the both of us. Since then, we have put both our search and our wedding plans on hold. My number one priority in my reintegration was to become independent and to set an example for girls coming behind me that change is possible. But I am not independent. At 43 years old, without my mom, I will be homeless. There is not one lease receipt that comes in my name, although every rent check is in my name. I asked the members of the housing committee, have you ever been faced with a choice? Leave the home where you feel safe or marry the person you love and face housing insecurities? Or
3 minutes have concluded. If you can please summarize.
okay. Or face housing insecurities because of a poor decision I made in 1996. Housing is a basic human right, and a criminal record does not strip you of your humanity. I ask that the members of the Housing Committee support HB 6948 to eliminate barriers for housing for people living with a criminal record like myself and many more who are doing positive things and changing and showing that we can be productive members of the community. I thank you so much for your time.
Thank you, Ms. Ledbetter. Seeing no questions from our committee, we will go to Ramidi Sharif, followed by next page, followed by Manuel Sandoval, and then Eli Sabin.
Good evening, everyone. Good morning. Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Ramidi Sharif. I was born and raised in New Haven, Connecticut. I'm an organizer with New Haven Rising. We are a grassroots organization fighting for racial and economic justice. We have surveyed thousands of people, thousands of families, and their priorities are clear. Good jobs, affordable, safe housing, and fully funded cities that provide opportunities for all youth to thrive. I stand here to support HB 6889 and believe all tenants should have just cause eviction protection. I'm also involved in street outreach to young people at risk of being involved in violence. We all know that the root cause of violence are a lack of access to good jobs, affordable housing, and youth opportunities, poverty. Connecticut is one of the most segregated and unequal states with one of the worst racial wealth gaps in the country. While these might be abstract facts to some of y'all, for me, this segregation and lack of opportunity has meant heartbreaking tragedies for families who have lost their kids to violence. I myself have lost my nephew several years ago. In New Haven, we've seen a lot of investment and change, yes. $2.5 billion of public and private funds have been invested in biotech labs and luxury housing. And yet wages for working people have stagnated, rents have doubled, eviction rates have increased in the same segregated pattern that has plagued New Haven for generations. What do you think? Do you think happens to youth when their families are evicted for no fault of their own? What happens when their families are stuck struggling to find a place in a city with skyrocketing rents? How can kids focus on schoolwork and developing themselves in positive ways when they are terrified that they may lose their homes? This year alone, you can all take an important step that will give families more security and will mean youth have more hope. No one should be evicted without cause. And this is something you all can help with. I had something very scoped out and for my testimony that I wanted to read real quick. But I am asking you all to look into your hearts as men and women that have been charged with guarding our cities with your elected powers, with your political powers, and make the right decision to give your brothers and sisters, sons and daughters, the same dignity that you are able to live with. Give our community and our residents and the hardworking people in our cities the same peace of mind and security that you all have. This is what we're asking for. This is what we demand. It's a shame that fathers and mothers that should be laying down getting ready for work have to do testimonies to wee hour in the mornings to try to get relief, to try to ask for some relief, some decency, some dignity to people that were charged in leading us in our communities and our nation.
Thank you, Mr. Sharif, for your testimony. Seeing no questions, we will go to Manuel Sandoval.
Hello, Senator Marks, Representative Felipe, and all the members of the Housing Committee. My name is Manuel Sandoval. I live in New Britain. I'm a licensed clinical social worker and leader with the ACLU Smart Justice Campaign. I'm here to support HB 16948, which addresses the collateral consequences of criminal records on housing. As I stand in support of this bill, I ask, when will the hypocrisy end? Why must those of us who have paid our debt to society continue to struggle for basic rights, for housing and employment? When just 4 months ago, a majority of voters voted for a person with a convicted felony to hold the highest office in the land. But somehow our records are seen on an unsurmountable barriers. Why is it? Is it because he's rich, white, and has lawyers and power and power beyond compare? Why are we left to beg for scraps? Why are we condemned to the margins of society, deemed unworthy and of equal opportunity? The idea that a person's punishment should be beyond their sentence is unjust. A just sentence is meant to cover their offense and the prescribed punishment, nothing more. Once someone has completed their sentence, they should be able to move forward with their lives. Yet year after year, we find ourselves advocating for basic needs, housing, employment. Where's the justice in this continued struggle? When will this perpetual exile end? For 8 years, the Smart Justice Campaign has come before this legislature, only to see our bills watered down and cut apart. But this year, we say enough is enough. If a person convicted of a felony can be the president of the United States, then surely those of us who have paid our debt to society deserve a chance to rebuild our lives and have stable housing and employment. I urge the members of this committee to reflect on our history, one that is marked by institutional discrimination and exclusion. From the Indians Removal Act, the Black Codes, and the Chinese Exclusion Act, the internments of Japanese Americans, and the era of Jim Crow laws, our nation's past is fought with injustice against marginalized communities. It is time we shift our mindset and approach. Housing is not a privilege, but a fundamental human right, essential for social equity, economic stability, and well-being. HB 6948 is a critical step in dismantling the barriers that prevent formerly incarcerated individuals from re-entering society. We must invest in community-based solutions rather than in costly, harmful systems. I urge you to support this bill and take a stand for justice. Let's ensure that people have paid their debt to society can move forward with dignity and opportunity. Thank you for this consideration. Also, earlier I heard someone say that it was Senator Sampson said that he doesn't lump people lump good actors and bad actors together, or something to that effect. And I like to say that, you know, if that's the truth, then why are we opposing this bill? You know, you don't know who's a good actor, who's a bad actor, but you know what? The people that have did some harms and have come out to the other side. We know the difference, and we've been able to change our lives, and we're asking for that redemption to be able to just move forward. You can't just keep saying that, oh, they're not worthy, when you don't know what their story's been. You don't know what happened. You know, I mean, we're here year after year,
Mr.
and every
Sandoval,
single
your
time we get everything
time
gets
is up.
chopped up.
Could your time has expired a bit ago.
Thank you for hearing me. I'm sorry, ma'am.
Yeah, thank you. Any questions from anybody? Nope. Okay, thank you so much for your testimony. Next, we have Eli Sabin, followed by Erica Christensen. Welcome, Eli.
Thank you. Good morning, chairs, ranking members, and members of the Housing Committee. My name is Eli Sabin, and I'm the legislative coordinator at Connecticut Voices for Children, a research and advocacy organization working to ensure that Connecticut is a thriving and equitable state where all children achieve their full potential. We submitted written testimony on a number of bills, but I want to use my time tonight to testify in particular about Senate Bill 1303, an act concerning non-resident landlord registration and increased penalties for repeat building and fire code violations, and House Bill 6889, an act concerning evictions for cause. First, Voices supports Senate Bill 1303 because it will help municipalities enforce the housing codes that ensure renters live in the safe, quality housing they deserve. Many landlords across Connecticut are violating local and state housing laws and failing to provide good quality housing to their tenants. That's why we're excited to see Senate Bill 1303 make natural person ownership disclosure requirements mandatory statewide in towns with more than 25,000 residents. By requiring landlords to submit contact information for owners and the person in charge of maintenance, Senate Bill 1303 will help hold absentee landlords accountable and make sure maintenance and safety issues at rental properties are addressed quickly. As Chief State Housing Prosecutor John Kerwin explained in his testimony many hours ago, state code enforcement officials currently do not have enough information from many absentee landlords to file criminal warrants against them for housing code violations. Landlords give their name and put a P.O. box as the residential address, and then the state cannot write a warrant to hold them accountable. That impunity means tenants going without heat in the winter, mold and rodent infestations getting worse, or smoke detectors not being replaced. We do have one change to this bill that we recommend. We agree with Attorney Kerwin that the bill's changes to the penalty structure need to be amended so they do not reduce penalties for second violations. Overall, though, we strongly support Senate Bill 1303 and urge the Housing Committee to finally get this legislation across the finish line so we can close this dangerous loophole and keep tenants across Connecticut safe. Connecticut Voices for Children also supports HB 6889, an act concerning evictions for cause. Given our state's affordable housing crisis, CT Voices believes that existing just cause eviction protections should be extended to all renters to help protect their rights in an inherently unbalanced system. HB 6889 will protect tenants from harmful eviction practices that contribute to long-term housing insecurity, job loss, and a myriad of negative social and economic consequences. It's important to be clear about what just cause evictions protections actually entail. Under the bill, landlords retain significant control over the properties. They can still evict a tenant for violating the lease, causing problems that affect other tenants, or if the landlord is moving into the unit or taking it off the market, or asking for a fair and equitable rent increase that the tenant doesn't want to pay. But crucially, the bill would level the playing field to create more stability and protection for tenants. Right now, a tenant being able to stay in their home, which can be essential to their life, to keeping them in their community and their kids in school, is fully at the whim of their landlord. As a renter myself, I felt the fear and instability that this powerlessness creates. Knowing you can be forced to pack up and move for no reason at all is scary. That's why just cause protections are overdue and why we urge the committee to pass just cause. And finally, I want to highlight CT Voice's support for HB 6944, an act requiring a municipality to include certain information in its affordable housing plan. This bill will help move our state towards a real solution to the affordable housing crisis, allowing towns to take the lead on building housing so that families have more options and our economy can grow. We respectfully urge the committee to pass HB 6944. Thank you all for your work and for listening to folks from across the state all day and into the night.
Thank you, Eli. Seeing no questions, we will go to 145, Erica Christensen, followed by 151, Thomas Birmingham. Erica?
Good morning, senators and representatives of the Housing Committee. My name is Erica Christensen, and I'm a renter in Simsbury, specifically the Weetog portion. And I'm here this early morning to testify in support of House Bill 6889 to expand Just Cause. So, as a renter, I moved to Canal Place Apartments on February 1st, 2020. At that time, I had a local landlord, Fish Enterprises, who employed not only polite, respectful, and courteous office staff and maintenance workers, but also promptly addressed any and all maintenance issues I reported. There was never a maintenance request that was not addressed that same day, even if reported after hours. Additionally, if maintenance stopped by to address my issue while I was away, I always returned to a note communicating to me who had worked in my unit and what they had completed. I felt safe, protected, appreciated, and respected. While living in my apartment at Canal Place, I developed a community and camaraderie with many of my neighbors. I truly enjoyed living here with a rent I could afford as a nanny. Due to the retirement of the owner, my complex was sold. The purchasing entity is an out-of-state corporate landlord. Things deteriorated quickly after the ownership change on August 17th, 2022. When I returned from work that day, I discovered multiple notices on my door. One was from the original owner, thanking me for my tenancy and letting me know that the complex had been sold. The others were from the new owner, Red Tail Residential, informing me that they were the new landlord, and another form asking me to complete communication paperwork for their online portal system. At first, this seemed great, but as you can probably guess, things turned sour and quickly. I completed the form and returned it via email on August 21st, 2022, prior to the requested deadline. I patiently waited for my portal access to be granted. I checked with neighbors as I waited, and they confirmed they had been granted access. Unfortunately, less than 2 weeks later, I returned home to a rotting smell. It was coming from the closet in my front bedroom. I completely emptied the closet, could find no holes or any clear source of the smell, but deduced that it was likely coming from a dead rodent within the wall cavity. By this point, I could no longer wait on property management for communication and portal access. I called the number I had been provided with when the notice of new ownership had been left for me, and instead of speaking with anyone local, my call was directed to a call center, despite my calling during business hours. During my conversation with the call center representative, they simply offered me exterminator services and then reached out to my property manager. After the phone call with the call center, Yanis Negron, the multi-site property manager for Canal Place and 2 other apartment complexes, called me. She stated that my portal had been set up and I should have received the email. I informed her that I had not and asked her what email address she had on file. Somehow, despite the fact that I had emailed her my form and was required to provide my email address on the form as well, property management failed to create my account with my correct email address. She fixed that issue and I was able to log into my account and submit maintenance requests for a period of time. As for the exterminator, it was nearly 2 months before they ever arrived. While waiting on the exterminator, the smell dissipated after a few days, as is typical of a decaying rodent. However, nothing was done to address my reported issue, nor has anything been done to my knowledge to investigate and ensure the issue will not recur, even to this day, nearly 2.5 years later. Days later, though, from this rodent smell, on September 1st, 2022, I noticed water leaking into my front bathroom from the ceiling, and thus coming from my upstairs neighbor's bathroom. I promptly reported this via my online portal on September 5th, 2022, and expected the issue to be resolved within the next 24 hours. I waited 3 more days as the issue persisted before following up again, and then again, and yet again. Ultimately, the water leak was repaired, but almost 3 complete months after.
Thank you.
After it first began. Ultimately, I ended up with a housing code enforcement action, notice of non-renewal, harassment, threats of towing my vehicle, a whole litany of things. I have been subjected to a just cause eviction and have recently been ruled against despite mountains of evidence and mold, chronic illness, and many other delightful gifts from my landlord. I'm open to any questions you would like to ask.
Thank you, Ms. Christensen, for your testimony. Seeing no questions, we will go next to Thomas Birmingham, followed by Ty Michaels.
Good morning, everyone. Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Thomas Birmingham, and I'm a resident of New Haven. I'm a tenant who emphatically supports HB 6889, an act concerning evictions for cause, and I believe all tenants should have just cause eviction protection. And today I'm going to share a side effect of not having just cause protections that I believe has been overlooked thus far today. I'm a journalist and investigative reporter who has been covering housing since 2020. I've broken stories exposing severe wrongdoing on the part of both landlords and local municipalities that have led to changes in legislation and other reforms. But the only way I'm able to do this kind of work is if tenants are willing to share their stories with me. And without just cause protections like the ones outlined in HB 6889, many tenants in this state are afraid to speak with the press. Last year, I was working on a story about tenants who contracted severe respiratory conditions like asthma as a result of mold that their landlords had allowed to fester in their apartments for months or even years. At one large complex, I went door to door and heard many horror stories from infants in and out of the emergency room to heart attacks induced by tenants not being able to breathe. The tenants in these conditions were holding up their end of the contract. They had asked for help from the landlord and the city of New Haven to get their conditions fixed, and they'd been largely ignored. But there was a significant barrier blocking them from exercising their right to seek help elsewhere by talking to the press, and that was the threat of eviction, and specifically a no-fault eviction. Many tenants requested to not have their names be used because they knew they would be kicked out and likely become homeless if the landlord found out they'd talk to me. Others didn't want me to put any parts of their story in the piece at all for this reason. And who knows how many didn't even answer the door or engage with me simply because they were afraid of getting caught speaking with the media. And I mean, right now, the tenants who are testifying at this hearing today could be evicted solely because they decided to share their story here with you. Without just cause eviction protections, we will never truly know the state of housing in Connecticut because tenants will continue to be afraid to talk about it. And I believe the lack of just cause protections in the state is depriving countless tenants of their key constitutional rights enshrined in the First Amendment, and also creating a hierarchy where landlords have a right to free speech while tenants do not. Landlords are free to form organizations like the Connecticut Apartment Association to coordinate media strategies and make their members constantly available to speak with journalists about whatever problems they've decided are worth complaining about that day. But if tenants seek to do the same to raise awareness to their life-threatening conditions, they can be and often are evicted for it. And I just don't think people's ability to exercise their basic constitutional rights should change based on whether or not they own property. So if you are a defender of free speech, as I know many on this committee purport to be, you should join me in strongly supporting the expansion of just cause eviction protections. Thank you, and I'm happy to answer any questions about this piece of the puzzle.
Thank you, Mr. Birmingham. Ranking Member Sampson.
Thank you, Madam Chairman. Thomas, thanks for being here today. I'm just trying to follow your argument. Certainly, I mean, I think everybody across our entire committee certainly wants to defend the rights of our constituents when it comes to their constitutional rights, for certain, free speech among them. Are you suggesting that because a landlord wants to reclaim their property at the end of a lease, that they are somehow denying the right of a citizen to have a tenant to have free speech? I'm just trying to follow. I mean, I'm sympathetic to all of the other aspects of your testimony and the things that people have suffered, and I want to find a solution to solve those problems. But I'm having a difficult time understanding how people are being denied their right to speak up.
Sure, it's pretty simple. Landlords right now have the ability, if they see that one of their tenants spoke out in the press about the conditions and their needs not being responded to, they can evict them for that at the end of their lease term. And that can be the only reason they have to file for that eviction and not decide to renew the lease. So yeah, it's not more complicated than that.
Ranking Member Sampson.
Thank you, Madam Chairman. I appreciate that answer, Thomas, although I mean, that's not an eviction. I mean, the fact of the matter is that when a lease term is up, that's the end of the lease term. There is no agreement beyond that day. And somebody being asked to leave, that's something they already agreed to. If they decide to stay even beyond that lease term and the landlord is forced to evict them, that's not retaliation. I've heard this over and over again today, but it doesn't make any sense. The fact is, when the lease ends, the lease ends. And that's your obligation at that point to honor the lease and leave. It only becomes an eviction if the landlord is then forced to remove you because you won't leave, even though that's what you agreed to. And how that intersects with whether or not someone has the right to speak, I don't get it, because there's no retaliation there. I mean, saying it's pretty simple, I'm not following it.
Mr. Birmingham? I'm not
Yeah,
sure.
of course.
Question.
Yeah, so when it's mostly about the imbalance in power in this relationship. Like I mentioned in my testimony, landlords are entirely welcome to coordinate amongst themselves and how to talk about the problems they're facing with the media, and can face no repercussions along the lines of being forced to leave their home for doing that. Tenants can, because again, with the existence of a no-fault eviction, if a landlord sees their tenant speak in the press about their conditions and does not like the fact that the tenant did that, then they can decide to make that tenant leave. And I'm also a little bit confused by your bringing up the idea of a landlord being forced to get rid of their tenant. I'm not sure the conditions that would force a landlord to do that aren't outlined in the existing for cause reasons that wouldn't be affected by the passage of just cause legislation. So,
Ranking Member Sampson?
Thank you, Madam Chairman. Again, I don't want to, split hairs with Thomas here. I think we just have a difference of opinion about the language that we're using. And I just disregard the commentary, because it's just hyperbole to say that at the end of a lease that a landlord is evicting someone by expecting that person to vacate the premises if they've been asked to. I mean, when you sign a lease, it is for a period of time. It ends on a certain day. And if the landlord notifies the tenant that they are not going to renew their lease, it's expected that they're going to leave. That's not retaliation. There's nothing retaliatory about that. That is what was agreed to. Both parties live up to their obligation. No one has an obligation to the other party. The tenant certainly doesn't have an obligation to stay if they don't want to. We wouldn't say that's retaliation. I'm retaliating against my landlord by not staying beyond the lease. You wouldn't say that. So it's absurd to say that the landlord is retaliating for not renewing the lease either. And just to answer your question, what I'm saying is that if the tenant chooses to stay beyond that date, even though they've been advised that the lease is not being renewed, then they are in violation of the lease, because then they're staying and they don't have the right to be there. And then the landlord would be forced to go and through an eviction process to remove them. We can talk about the bill and how that changes that fact. But under current law, those are the circumstances. I just, if you're going to go around and suggest that somebody is depriving other people of their constitutional right to free speech, I mean, you should have a stronger argument than somebody simply expected them to the other person to abide by a contract they signed. That's all I would suggest. Thank you, Madam Chairman.
Thank you, Ranking Member Sampson, and thank you, Mr. Birmingham. Next, we will have Ty Michaels, followed by Maricelis de Jesus Ocasio. And if you are out there in cyber world, please accept the panelist invite so that you may testify. Ty, go right ahead.
Great. Thank you, Madam Chairwoman. Hello, my name is Ty Michaels. I'm a resident of New Haven and a renter, and I'm also here in support of HB 6889. I've been a renter for as long as I can remember, and in that whole time, since before I moved to Connecticut, I think I had never really thought of Just Cause. I come from LA, where Just Cause protection has been in place for almost 50 years. It's something that people just kind of take for granted that they have a right to treat their apartment as a home. And I think that protection is something that is deeply important to me. So coming to Connecticut, I was really surprised that Connecticut, as a very progressive state, as a state that is more than 70% renters, does not have these kinds of protections. And I think it's just felt very real to me in my current apartment, with broken windows that have been here since the beginning, with rodent infestations that the landlord has not addressed, with the landlord overcharging us for rent since the day we've moved in. And I would honestly call this the second best landlord I've had of the 5 I've had in New Haven. I think it just really puts in perspective how essential just cause is. I think, a lot of people on this testimony have talked about retaliation and how it fits into all of this. I think there are very real mechanisms that we have at our disposal to ask and demand that the landlord fix these things. But in the end, the landlord always holds the power to kick us out in the current system. There are protections against retaliation, but there is always the option of non-renewal. Non-renewal does not have to be retaliation, but it can be retaliation veiled as non-renewal. And because landlords won't kick us out for no reason generally, we as tenants avoid pushing them to do things that they are contractually obligated to do for us, because they always hold that power. Because by doing that, we make themselves problems in their eyes just by demanding that they do right by us and do what they said in the contract they signed with us. And so because of that, I think I just view this bill as very essential to kind of living in the state. I think the right to have a home is incredibly important, and saying that just cause is not necessary is equivalent to saying you can afford to buy a property outright, have a right to have a home. And I think that's just unattainable to so many people, particularly people of my generation, who grew up in a society where housing is increasingly unaffordable and only accessible to those who grew up with a home to begin with. So yeah, I think that sums up my point, and I'm open to questions.
Thank you, Ty. Seeing no questions, we appreciate your testimony. Maricelis de Jesus Ocasio, followed by Faiza Hussein.
Hello there, everyone. My name is Maricelis de Jesus Ocasio, and I'm here today as the Congregational and Community Organizer of the Collaborative Center for Justice to urge you to expand just cause eviction protections. As a 23-year-old renter who lives alone and supports myself entirely, the idea of no-fault eviction haunts me. Without a close relationship with my parents, who have both struggled with substance abuse since I was born, and my father passed away when I was 16, I do not have a safety net to fall back on. If I were forced out of my home for no reason other than my landlord's decision, I would have nowhere to go. Rent is my largest monthly expense, and as a young person juggling student loan repayments, electricity costs, car payments, insurance, grocery costs, and so on, my bank account is often empty at the end of each month. The financial burden of simply trying to survive is already very overwhelming, but the looming fear of no-cause eviction or lapse of time only heightens this anxiety. Stability feels out of reach when I know that I could be told to leave, not because I've done anything wrong, but because my home is more valuable to someone else. I've seen this happen firsthand. My best friend, who has submitted written testimony, was pushed out of their home when new buyers took over, funneling in wealthier tenants who could afford to pay 3 times what their family could. They were given no real choice, no real protections. And this isn't an isolated incident. As I'm sure we've all realized sitting here listening to all the testimony today, this is a pattern. It's happening across our state, stripping working class people, young people, and families of independence and the security they need to build their lives. Expanding just cause protections is not just about policy, it's about dignity, it's about ensuring renters have a fair chance at stability. We deserve to know that if we meet our obligations as tenants, we won't be displaced. We deserve the ability to lay down roots and build our futures without the constant threat of being forced out. We are counting on you to make this happen this legislative session. Thank you for your time and hopefully your commitment to protecting renters.
Thank you for your testimony. Seeing no questions, we will go to Faiza Hussein, followed by followed by Chelsea Ross.
Dear members of the Housing Committee, my name is Faiza Hussein, and I am a dual degree graduate student at Tulane University and an MSW intern at Universal Healthcare Foundation of Connecticut. I am here today to testify in support of HB 6889, a bill concerning evictions for cause. Before I begin, I want to thank those of you who are still here, listening and giving people the opportunity to be heard. Watching this testimony unfold over the last 15 hours, I want to acknowledge the patience and dedication it takes to truly listen, and I apologize in advance if I stutter from exhaustion. From the testimonies we've heard today, I doubt there's anything I can say that will shift the minds of those who entered this room already decided. But one fact remains indisputable. This is not merely about leases. It's about power. Some people may feel entitled to label the right to stable housing as radical. But in a public hearing where individuals are given 3 minutes to expose their vulnerabilities, trauma, and lived experiences, just to assert their fundamental right to a home, for them, this is not radical. It's survival. And this is unsettling that such a concept even requires justification. Because if we're calling basic fairness radical, then what do we call unchecked power that allows a handful of individuals to exploit marginalized groups, displace families without cause, and take advantage of an imbalance of privilege that allows a select few to dictate the stability of those barely managing to survive? We've heard it said today that the end of a lease term is not an eviction, but for tenants, the result is the same. They pay rent, follow lease terms, and abide by their agreements. But when landlords use this bill's loopholes to force them out without justification, where is the fairness in that? Because for a tenant whose life has just been upended under the guise of lease ending and who is now unhoused, scrambling for shelter in an unaffordable market, it's no different from eviction. This bill will prevent landlords from exploiting this loophole, a mechanism used to circumvent the legal process of eviction while retaining absolute power. On paper, tenants have right. But what is the practical value of a right when those who need it the most lack the resources, time, or privilege to defend it? For working class families juggling multiple jobs just to keep a roof over their heads, there is no luxury of lengthy legal battles or bureaucratic delays. And the individuals fortunate enough to sit here nitpicking the lived experiences of the people testifying today are also privileged enough to never know the desperation of cracking a car window while sleeping with a toddler in below freezing temperatures, just to avoid becoming another statistic of carbon monoxide poisoning. This bill does not take rights away from landlords. It simply levels an already uneven playing field. Not about landlords losing control of their property, it's about people losing control of their lives. And if that reality does not unsettle us, if we can hear these stories and still fail to act, then the issue is not radical nature of this bill, but the disturbing ease with which we have normalized human suffering. Thank you.
Thank you, Ms. Hussein. We have a question from Senator Sampson.
Madam Chairman, thank you. Faiza, thank you very much for your testimony. It was very powerful and very passionate, and very similar to a lot of the other testimony that we've heard today. You know, I've spent the whole day listening to very similar stories, and I find them all extremely compelling, and certainly I can understand what it might feel like to be in the circumstances that you described. But this is a policy question for us who have to vote on this type of thing, and sadly, we're not often given a lot of choice in the final product. It's either you're going to accept this bill with these terms, yes or no. And I'll have the opportunity to offer amendments and so forth, but they will be rejected, repeatedly, and I'll end up having to make a vote on the final product of the bill. What I wanted to ask you is, make another quick comment first, which is that some of what you say, you lose people like me when you start talking about the landlord having privilege, etc. I mean, people work for their money, and they take risk to own property, and particularly when they become landlords and they offer it. offer a property available for rent. And there's plenty of people that are doing that very honestly and with no ill intent whatsoever, and they're bringing good into the world. So that it's frustrating to hear that perspective. And I really struggle with the notion that all of this conversation, as I mentioned not too long ago, has become, there's animosity between tenants and landlords. There's animosity between employees and employers. It's frustrating. It shouldn't be that way. People should find ways to work together to resolve these problems. So, the problem I have with this bill is that it shifts the right to decide what to do with the property from the owner, who I believe rightfully has that power to decide. They paid for the property, they took the risk, they should decide how it's used. They transfer the use of the property to a tenant for a specified period. There's a contractual agreement both parties should honor to the letter. And when either party violates it, they should be punished. They should be admonished to fix it. The bill shifts that power to control the property that you described as an imbalance to the tenant, because effectively the tenant will then have the power to decide to stay there even over the landlord's objections. That's not a good solution in my view. I picked you because you're very intelligent, clearly from your testimony. And I just want to offer an alternative, which would be, would it make sense to just find a way to provide some sort of notice provision to a tenant that, is well in advance of a lease expiration to say, look, I'm the landlord of this property. I have decided that I'm not going to renew your lease because of whatever reason. And it doesn't have to be a retaliatory reason. It could just simply be, I need to use the property for some other reason, to offer it to another person, whatever. As long as that notice period is long enough, I believe that allows the tenant the ability to find new housing. And I would just close by saying that if you're actually a good tenant, which I suspect you are, and you pay your bills and you're on time, as much as people want to make it out to be that it's very hard to find housing, under those circumstances, it's not. I can tell you that there's 3,500 units available on Realtor.com right now. Probably many, many more if you start looking in other places. A lot of people that have difficult things in their background, poor rental history, job history, poor credit, they're going to have a tough time. There's no question about it. But good tenants, they really can write their own check and find a place. So I just throwing that out there. If you hear anything I'm saying as a potential compromise, and that if notice makes any sense as an alternative to shifting the balance of power, through you, Madam Chairman, and thank you for indulging me with the long question.
Sorry. I appreciate you responding to me, Senator Sampson, and I do not feel confident enough to answer that, but I would defer to my advocates to answer this issue. This is my first time testifying, but yes, if anyone else was confident enough to answer this, go ahead.
Thank you.
Okay, that's fair. Thank you.
All set. Thank you. Next, we will go to Chelsea Ross, then Karen Ellis, then Dennis Crow. Chelsea?
Good morning. Can you hear me okay?
Yes, we can.
All right. Good morning, Senator Marks, Representative Felipe, Representative Scott, Senator Sampson, and members of the Housing Committee. I want to take a moment to acknowledge the incredible bravery of some of the people who've testified over the last 14 plus hours. Sharing your personal stories of housing instability and eviction and homelessness is raw and painful. And your voices have really been the heart of this conversation. I'm deeply grateful for your willingness to speak truth to power. Your courage really demands that we listen and that we act. I'm Chelsea Ross. I serve as the Executive Director at the Partnership for Strong Communities. We hold the value that a home is the foundation for everything, our health, our education, our economic security. Without a stable home, nothing else can be stable. excuse me, for thousands of Connecticut renters, that stable foundation is at risk, not because they've done anything wrong, but because Connecticut still allows no-fault evictions. So as such, we support HB 6889. Our rental market is broken. Rents have surged 29% since 2021. Wages have barely moved. I've been listening since 10:30 this morning, and I know you've heard all of these facts that eviction filings are now higher than before the pandemic, and no-fault evictions where tenants are forced out through no wrongdoing still make up 11% of cases. And that's just what we can count. Many more renters don't make it to court. They quietly leave to avoid the trauma of fighting a system they know is stacked against them. You've heard about the impacts of eviction being devastating. Families are thrown into crisis, kids are forced to change schools, communities are destabilized, and the most people at risk are children, and that's heartbreaking. My children are sleeping safely in the next room because as a homeowner, I have the privilege of stability. Nearly half of the families who receive free legal help through Connecticut's Right to Counsel program have young kiddos at home. Children who experience eviction are more likely to struggle in school, more likely to suffer health problems, more likely to experience poverty in their adult years. Excuse me. So HB 6889 is a fair and necessary expansion of existing law. It doesn't prevent landlords from evicting tenants for all the reasons we've gone over. We need thousands more affordable homes, stronger investments in rental assistance, and real zoning reform. But renters can't wait for those solutions when they're dealing with instability right now. If Connecticut is truly committed to affordability and opportunity, we have to stand with renters and pass 6889. We urge you to vote yes on this bill. I'll also note that we submitted written supportive testimony on 4 other bills, 6939 on right to counsel, 6941 on the income disregard within the rental assistance program, 6947 on pricing algorithms, and 6948 on collateral consequences of criminal records. And we'll be submitting on 6938 on increasing the number of rental assistance certificates. Thank you.
Thank you, Ms. Ross. Ranking Member Sampson.
Thank you, Madam Chairman. And Chelsea, thank you for being here. I guess I just want to take a small issue with some of your testimony, because you said over and over again that people were being evicted through no fault of their own. And we did hear from, numerous attorneys, some representing tenants and some representing landlords, and they all explained the process very clearly and very much the same, which is that under current law, what happens is if someone overstays their rental beyond the expiration date and they leave the landlord no choice, the landlord then has to take them to court via an eviction. So I don't see that as a no fault situation. I see that as the tenant overstaying. I wonder why that is such a struggle for people to recognize that a lease has a specified term that both parties agree to in the beginning. If somebody wants to stay beyond the agreement, how can that be no fault? Through you, Madam Chair.
Ms. Ross?
Thank you, Senator Sampson. I appreciate that you take issue with that. 6889 presents another way that we could look at, how people maintain stable tenancy. And I think, other testifiers tonight and yesterday have addressed that much better than I can. Thank you for your question.
Senator Sampson.
Thank you, Madam Chairman. Okay, well, I won't press you. I feel like I still haven't had a good answer to a couple of my questions. I'll give you an opportunity if you want to take it or not. And that is, number one, under current law, effectively, when the lease expires, the tenant should just leave if that's the arrangement that has been made by the landlord via a notice process that is stipulated in the contract. And that's not retaliatory. That it was the expectation at the beginning, just like I compared it to if you rent a car for 5 days, Well, you got to return the car after 5 days. Can't keep it for 6 days because then they're going to be wondering where their car is. And it's the same kind of concept. I fully understand that it's difficult. I'm not saying it's not difficult, but the fact of the matter is, if you need to have stability in life, you need to plan for that by having an arrangement with the housing provider in advance by saying, gee, Mr. Landlord, you know, I'm going to rent your place. How long am I going to be able to stay here if I decide to? Are you planning on selling the building? Are you planning on doing this? So you have that communication and relationship, because the fact of the matter is the property does belong to the landlord. I'm sorry for going on, but my question is, if we pass this just cause legislation, which effectively now says that the landlord's got no more power, the tenant holds the power, they control the property, because now the landlord's only opportunity is to evict them. They actually have to go and take money out of their pocket. They got to hire a lawyer. They got to file paperwork, and they got to go to court to tell the court, look, I want this person removed from my property, even though we signed a contract together that they have to leave on this day. They say they're not leaving. And now the bill also says that you only have certain reasons. And if your reason doesn't fit into that, then you're out of luck. Your tenant gets to stay forever. So this bill doesn't have a timeline. It basically says that the tenant their tenancy will endure forever unless the landlord comes up with one of the reasons. As long as that person keeps paying rent, as long as that person doesn't violate other terms of the lease, they essentially control the property. And I have a problem with that because they are not the person that bought the property, who invested the money and took the risk. My question is, for anyone who's willing to take it, how long is that supposed to last? How long should the tenant have the right to displace the actual owner of the property? And I don't mean that I can ask anybody who's waiting, James. I appreciate it. Maybe we'll get the chance to talk, but I'm offering that question to Chelsea. She doesn't have to take it. I completely understand, but that's my question to people who are advocates for this bill. And thank you again, Madam Chairman. I'm going to try not to extend this any further.
I appreciate that. Ms. Ross?
Thank you, Senator Sampson, Senator Marks. You know, you said that people can just leave. You know, your words where you took issue with something that I said. I really take issue with that someone can just leave, as if there are other places to go. I think earlier you said, you know, there's 3,500 apartments on realtor.com or whatever it is. I'm sure that most of them I can't afford right now. So, you know, if I had to leave my home with my children tomorrow, I wouldn't have a lot of options. So I take issue with the statement that, you know, people can just leave. And then, you know, you also shared that in your opinion, this gives the tenants all the power, which I guess would potentially imply that currently the landlord has all of the power. And so I think 6889 provides a better balance of power. It doesn't take away a landlord's power. So I know, you know, James is chomping at the bit to answer your question on the timing question. And I see some other great experts here who maybe have less of a cold than I do, and feel like going toe to toe to you on that, with you on that one, Senator Sampson.
Thank you, Ms. Ross. Are we all set, Senator Sampson?
I just want to thank Chelsea for her commentary. I hope she feels better. Just to clarify, my issue was that currently the property owner controls the property. In other words, they have the right to reclaim it at the end of the lease term. And if the just cause legislation passed, the tenant will then have the power to control the property, taking that away from the tenant. I can understand there's conversations about a power imbalance and so forth. And just with respect to me suggesting you just go anywhere, I understand that people are limited. Like, I mean, I can't go drive a Ferrari. I don't have the means to go have a Ferrari either. But that's also no one else's responsibility. And it's not the landlord's responsibility either. The landlord's responsibility was to abide by the terms of the lease, which began and ended on a certain day and required provisions for notification, etc., which presumably they lived up to. So that's all I'm suggesting. And thank you so much for indulging me.
Thank you, sir. Karen Ellis, followed by Dennis Crow. Can you unmute, Miss?
There we go. I was trying, thank you. Good morning. Co-Chair Representative Felipe, Senator Marks, and member of the Housing Committee. My name is Karen Ellis. I'm a resident in Milford, Connecticut, and a member of All In for Milford. I'm speaking in support of HB 6889, an act concerning evictions for cause. I think it might take a little bit different, but very meaningful and to me, and I think to many members of our state. I care about affordable housing in my city and in my state because diversity is the foundation, the strength of any stable and sustainable community. I do not specifically refer to diversity of race, religion, or ethnicity, although that will come naturally. I refer instead to the diversity of individuals and family, which comes from life experiences. Building a city on the backs of a singular economic group is impractical and unsustainable. It is a roadmap to stagnation. Ideas, opinions, and creativity become complacent if unchallenged or limited to the experiences of one specific economic group. The ability to expand, grow, and thrive can be restricted by the limited experience of a single group defined by any social or economic component. I care because we are all united, and what affects one affects everyone. Everyone should have an opportunity to live in a community of their choice. All individuals and families deserve affordable housing, a place that provides shelter, stability, safety, and a chance to thrive. Welcoming and embracing the differences in people from a wide variety of backgrounds and experiences is smart. Making space for everyone in our communities brings a wealth of experiences and a much broader spectrum of ideas and creative abilities to solve problems and support growth and stability in our towns and cities. I support HB 6889 because I've seen friends and families suffer evictions despite working hard, often to jobs and paying rent on time. Uncontrolled rent hikes and corporate buyouts are stripping away affordable housing. Even as we build more homes, essential workers like teachers, firemen, and young policemen and young professionals struggle to live in the city of Milford. Essential work, by protecting reliable tenants from arbitrary eviction and supporting responsible landlords, we can keep our communities vibrant and diverse.
Ms. Ellis, your 3 minutes have expired. If you can please summarize.
I just believe that it is important to provide living space and opportunities for all who wish to live in our communities, in our cities, and in our states. I urge you to pass this bill for the future of our cities and the many towns across our states. Thank you for this opportunity to speak. It has been an incredible experience, and I'm a first timer, so I appreciate what you're doing and what you've done, and for all the people who have been here. Thank you.
Thank you. Thank you for testifying, and seeing no questions, I am going to turn it over to House Chair Felipe, and Dennis Crow's next.
Member 161, Dennis Crow, the floor is yours.
Thank you. Good morning, co-chairs Felipe and Marks, ranking members Scott Sampson, and all the esteemed members of the Housing Committee. I'm Dennis Crow from Madison. And I'm going to switch gears here. I'm speaking in opposition to HB 6944, requiring a municipality to include certain information in its affordable housing plan. This bill creates an opportunity for interested parties, defined as housing advocate organizations or developers, to have the ultimate authority on planning for expanding housing in our municipalities. The bill sounds great. Towns develop their own plans, their own zoning changes to create a, quote, realistic opportunity for the development of the number of affordable housing units allocated to it. But the plan provides strict guidelines on percentages of housing applicable to low income and to very low income, but limits the amount age restricted, such as 50 and older. Creating a plan for specifying percentages in Madison is challenging because there are few larger lots available for building of complexes. All the land is expensive. Any lots in a TOD area, if that also comes to pass, are fully occupied and even more expensive. And allocating those percentages will require juggling low income in some neighborhoods, very low income in others, and perhaps retirement in others, and finding a way for developers to build. Add to that the problem that towns such as Madison have very limited town water, no sewage, no natural gas. I can predict the secretary will find any plan that we would submit to not have a realistic opportunity to meet its goals. Let's talk about the plan approval process. The plan gets submitted to the Secretary of the Office of Policy and Management. If he or she approves the plan, any of an unknown number of self-appointed interested parties can take the Secretary to court. Not stated, but predictably, the town can be dragged into court as well. If the interested party wins, the losing party, the secretary, is that the secretary or is it the town, can be fined and charged legal fees of both sides. If the interested party loses, there are no consequences identified in the bill. Consequently, the secretary is likely to reject plans that he or she might otherwise approve just to avoid a court battle that this so-called interested party would bring. And the bill has no stated recourse for the town to disapproval by the secretary. So there's a statement that the interested party can bring suit in Superior Court. There is no such protection for the town. Winner, the housing advocates and developers. Losers, the towns. There is a need for affordable housing in Madison and elsewhere, but we would be better to find ways to accommodate housing of various types, ADUs, senior living, duplexes, and others. This would reduce the backlog of demand and thus ease the pressure on prices. One size does not fit all. I urge the committee to rewrite this bill to realistically address not only the housing needs, but the circumstances of those diverse communities as identified by Representative Dubitsky, Representative Weir, Maria Weingarten, and others who preceded me since yesterday morning. Thank you.
Thank you, Mr. Crow. Any questions from members of the committee? Seeing none, we thank you for joining us this morning.
Thank you.
Next, we have 182, Jeff Farrini.
Good morning, Madam Chair, Chair Philippe, and members of the committee. Thank you for the opportunity to testify today. My name is Jeff Farrini, and I own and operate Trio Properties, a Connecticut-based company managing 2,500 rental homes in Connecticut. I'm also the member of the Connecticut Apartment Association and serve on the board of directors for the National Apartment Association. I strongly oppose HB 6889, 6891, and 6943, each of which would create unintended consequences that harm both property owners and residents. I know it's late, so I'll move swiftly through my points and welcome questions at the end. HB 6889, restricting evictions for cause only, for cause only. At one of our communities, we had a resident who blared music all night, trashed the common areas, and caused altercations in the parking lot. Residents repeatedly complained, but proving a for-cause eviction was nearly impossible. Neighbors are too afraid to testify. And by the time we could build the case, months had passed and the responsible residents had moved out. The way we restored peace, we didn't renew the lease when it expired. If this bill were law, that option wouldn't exist and the community would have suffered longer. You cannot create a safe and stable housing environment by making it nearly impossible to remove those who jeopardize it. For HB 6891, limiting security deposits to 1 month's rent, last year we had an applicant named Chris, first names only. He had marginal credit and a lower income than what was required, but he was at a turning point. He had a stable job and he had good references. Because we had the ability to require a higher security deposit, we took a chance on Chris. If this bill were in place, we would have to say no. Instead of getting a second chance, Chris and the roughly 150 other conditional applicants we accept annually would struggle to find housing. By restricting security deposits, this bill will reduce, not expand, housing access for those who need it most. In HB 6943, protections for residential tenants, specifically prohibiting month-to-month or holdover fees and changing payment prioritization. A few months ago, we had a tenant named Sarah, again, first names only. Her lease expired and we gave her a 60-day notice to renew or move out. She stayed past her lease without signing the renewal, preventing us from leasing her unit to another resident. Because we had a holdover fee or a month-to-month fee, Sarah ended up signing a new lease after 30 days, rather than continuing to pay the extra. This fee isn't about punishment. It ensures stability. Without it, tenants avoid lease renewals.
Your 3 minutes have expired. If you can please summarize.
Tenants could avoid lease renewals, disrupting occupancy and planning, leading to unexpected move-outs. Additionally, this bill mandates that landlords apply payments to current rentals before past due balances, which isn't really how it works in other industries. Imagine if a mortgage lender ignored unpaid balances, letting debts pile up indefinitely. This would make it even harder for landlords to collect unpaid rent. Fair housing policy should not rewrite financial responsibilities. Residents must pay their rent, and landlords should be able to collect unpaid debts just like any other business. Each of these bills will create a real harm in the housing market. They limit housing opportunities, tie the hands of property owners, and create instability for everyone. I urge this committee to focus on balanced policies that protect the tenants without eliminating the flexibility needed to operate housing successfully in Connecticut. Thank you very much. Happy to take questions.
Thank you, and we appreciate your testimony. I don't think I see any questions from members of the committee. And I'm going to say this once. I don't like to say it all the time because it seems self-serving, but it's Felipe, not Philippe. When people say Felipe, it sounds a little more European. I am proudly Latino. Thank you very much. Next, we have Amy Epler-Epstein.
Good morning, and thank you all for staying here for these important issues way into the morning. I felt compelled to stay online here and to be able to respond because I heard some of the earlier testimony, particularly Attorney Chesson, who I'm sorry, let me back up. My name is Amy Epler-Epstein. I'm an attorney at New Haven Legal Assistance. I represent tenants and have done so for over 3 decades. And I am a regular person in housing court as an attorney representing tenants. And I heard Attorney Chesson's testimony a couple of hours ago. He is a regular opponent in many of my cases. I think we both have a good deal of respect for each other. And I wanted to give a little bit of a different perspective on how that eviction process works and what it means to tenants and why it's so important that this committee pass HB 6889 to expand good cause protections. First of all, I find it sort of remarkable that the reason that all landlords are saying they need to have lapse of time eviction is in order to evict tenants who are causing a nuisance or who are squatters and have no right to be there. our laws provide a remedy for that. There are ways to bring those evictions and to bring it for those cases. And the landlord representative who said lapse of time, this is a way to, bring a quick, to deal with those problems quickly. Lapse of time is actually not a quick eviction. Under lapse of time evictions, a tenant can seek a stay for up to 6 months. And so if a tenant really is causing a nuisance, then a landlord should bring an eviction under nuisance. And if I represent a tenant and the landlord saying that they can't prove that, if somebody has a strong case and they have proof that and evidence that somebody is violating their lease or creating a nuisance, then there is ample opportunity to bring that to the court. And any attorney representing a tenant in that situation, if they felt like there was evidence there, then they would try to resolve that case in a way either that made sure that the tenant changed their behavior or that gave the tenant the opportunity to move out. So I think that's a terrible reason to try to keep lapse of time evictions and not require just cause, because there are remedies available for landlords to use if for problem tenants. You don't need to have just cause eviction in order to evict those people. There's much better options that already exist there. Instead, what I have seen over and over again in my decades of practice is landlords, and oftentimes big corporate landlords from out of state, who are using the just cause eviction to force people out of their tenancies that they've been there sometimes for years, paying their rent, excellent tenants. They may have connections to the community, and all of a sudden they have to leave. They've done nothing wrong because they're not covered by our just cause eviction laws that just protects a small number of tenants now. And oftentimes these landlords use that as a way to get around fair rent. Somebody will buy a property.
Christine, your 3 minutes have concluded. If you can please
Thank you.
summarize.
Yes, that it can be used to subvert or get around the fair rent commissions and rent increases, because landlords can bring an eviction without cause. And instead of trying to raise the rent, they just get somebody out. Thank you for the important work that you all are doing. I really appreciate your attention. And please, let's make this the year that we pass the expand just cause evictions.
Thank you for your testimony. I don't see any questions, so thank you for being with
Thank
us.
you so much.
Next is Delane Hall, number 193.
Hi, good morning, everyone. Thank you for having me. Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Delane Hall. I'm a resident of Bridgeport, Connecticut. I'm a member of Make the Road, Connecticut. I am a tenant and I support HB 6889, an act concerning eviction for cause, and believe all tenants should have just cause eviction protection. One day I complained to my landlord about the tenants playing loud music late at night. During this time, I worked overnight shift and needed my rest. The tenants would play loud music to the point where I could not catch my sleep. I nicely went and asked if they could lower the music just a little. They then proceeded to tell the landlord that I complained to them about their music. Days after, I got a letter stating that there's a rent increase. I said, okay, but now I want my repairs done if the rent was being raised. Before this moment, the landlord was already aware of the windows needing repairs, and there has been infestation of mice and roaches. She had mentioned she would fix it ASAP. She also took measurements and never fixed them. So when I saw that my rent was increasing, I started being more demanding about the repairs. She then said when she came back from her vacation, she would fix it. When she came back from vacation, she instead served me with eviction notice. It was hard going through an eviction process as a single mom working to provide a home, food, clothes for my son and myself. And now I had to look for an apartment because I was being evicted with no fault. I had only 30 days to leave the apartment stated by the court, and this was winter. You need a good credit score to be able to get an apartment, something that I didn't have at that moment. which made it harder to get a shelter for my child and myself. As I searched for a home, winter came, and thankfully I found something, or it would be winter in the streets with my son. With no family members in Bridgeport, this was a hard thing to put my son through. There are many families that are in the streets as we speak, looking for shelter and some good food. For these reasons, I strongly support expanding just cause eviction protection. Thank you for having me.
Thank you, Ms. Hall. I don't see any questions from members of the committee, so I'll just say thank you for joining us this morning.
Thank you.
Next, I know you've been waiting patiently, 194, Giovanna Shea.
Good morning, Representative Felipe, Senator Marks, Representative Scott and Sampson, Senator Sampson, other members of the committee. I'm Giovanna Shea. I'm our Litigation and Advocacy Director at Greater Hartford Legal Aid. I directly supervise the attorneys in our housing unit, and I'm in housing court at 80 Washington, including today. I'm here this morning to speak in support of HB 6943, which we haven't heard as much about. It's an act with a number of common sense protections for tenants. One that I haven't heard discussed this evening that is in HB 6943 would ensure that upon request, a landlord would need to supply a tenant with a copy of their ledger or equivalent accounting. I know it might be surprising to hear that folks have trouble getting copies of their ledgers, but you've heard all throughout the day that we do have an increasing number of out-of-state corporate landlords, even off-site property management. You heard that from Ms. Christensen earlier. And tenants can sometimes have difficulty getting access to the electronic portal. If a landlord begins an eviction, they may shut the tenant out of the electronic portal. We find that tenants really may not have a good understanding of the charges on their account, the fees, or what they are claimed or alleged to owe. One tenant that came to our office recently had signed an agreement unrepresented in court to pay back an arrearage that was about double what she was supposed to be paying. The monthly payment was about double what her rent would have been. She'd signed it without seeing a copy of her ledger. When we looked into it, it now seems likely that the balance on the ledger should have been adjusted and that arrearage was inaccurate. I think it's just a matter of common fairness to share with tenants their ledgers. One other provision of HB 6943 that Mr. Ferroni and I see differently is the end of month-to-month or so-called holdover fees. We're seeing these a lot more commonly lately. In Connecticut, many of you know from experience or have heard, it's fairly typical for the first lease to be a written lease, maybe a one-year lease, and then for tenants to have a renewal of oral month-to-month leases after that. Many tenants go on that way for years. That's very common among our clients. Increasingly, we are seeing coming into our office indigent, elderly, and disabled tenants, many of whom are surviving on Social Security or are low income or have fixed income, and they are being assessed hundreds of dollars each month in month-to-month or so-called holdover fees on top of their rent. And in Connecticut's context, where it's, very typical for folks to just have an oral month-to-month lease at the conclusion or expiration of their written lease, we think that those additional fees can be in many situations exploitative.
Please summarize. Thank you.
Finally, HB 6943 would prohibit marketing leases, form leases with provisions that are contrary to state law, and I think that's just a good matter of common sense. Thank you so much for your work, and have a good evening.
Thank you, Ms. Shea. We appreciate you coming before us. I don't see any questions, so thank you for joining us this morning. Next, we have Morgan Miller.
Hello, excuse me. Hello, good morning. Thank you for staying up with us. Thank you to all the members of the committee for the opportunity to provide testimony on several of the bills today. My name is Morgan Miller, resident of Salem, Connecticut, and I'm a volunteer member and currently sit on the board of directors for the Connecticut Apartment Association, an organization representing approximately 70,000 apartment homes across the state of Connecticut. I've already submitted my full written testimony. But as a CTA member and Connecticut housing provider, I would like to offer my support to SB 1305, SB 1307, and HB 6945. Due to the many bills that are being up for testimony and discussion today, I would like to speak in opposition to the following bills. House Bill 6889, evictions for cause. The existing eviction laws already have protections in place for tenants age 62 and older, anyone disabled, low-income housing, and subsidized housing residents. Lapse of time, again, is non-renewal of an agreed-upon lease contract, is not an eviction. A housing provider already has to provide 60 days written notice of non-renewal, and if a resident chooses to litigate, they're also provided up to an additional 6 months of protection to find additional suitable housing. Lapse of time is rarely used and is oftentimes a housing provider's only way of removing a resident who is breaking the terms of a lease and threatening the quiet enjoyment of the entire community, such as smoking in a non-smoking building, unauthorized pets, illegal drug activity, unauthorized occupants, and so on. Almost everyone is in agreement that we have a housing shortage, and we continue to hear about the need for more housing, yet this legislation takes away an important landlord tool and will unfortunately make it even less attractive for developers to build here. HB 6943, removing the premium for a resident to remain in an apartment beyond the lease expiration on a month-to-month basis will discourage housing providers from allowing month-to-month leases and also provide zero incentive for residents to sign another lease, essentially opening up housing providers to increased exposure and liability. Combined with the removal of lapse of time in HB 6889, and you will have tenancy in perpetuity. HB 6891, prohibiting a landlord from returning a security deposit in excess of 1 month's rent. This is anti-landlord legislation. Oftentimes, a housing provider will request an additional month's security deposit when someone doesn't meet certain rental criteria. This allows for people to get into apartment homes that typically wouldn't be ineligible. They would typically be ineligible for. The unintended consequences of this legislation would leave many marginal applicants even more limited housing options. HB 6892, CTA is committed to increasing the housing options in Connecticut. We have heard from members of this committee numerous times and over the past several years how Connecticut needs to incentivize the development of multifamily housing. The repositioning of multifamily asset is common and helps Connecticut revitalize apartments and add to municipal tax bases. This proposed legislation would deter developers from joining Connecticut's housing market and is effectively a form of rent control. Connecticut has the 5th oldest housing stock in the nation, and with the majority of the multifamily real estate having been built in the 70s and 80s, you are literally asking developers to choose another state to invest in. HB 6948, this bill endangers the hundreds of thousands of renter households in the state of Connecticut who choose their apartment home for a number of reasons, including the screening measures that their landlord puts in place. This bill will discourage new multifamily developments in the state of Connecticut.
3 minutes have expired. If you can please summarize. Thank you.
Absolutely. And will also drive up the cost of insurance premiums. The CTA believes that too many unscrupulous landlords have taken actions that taint the reputation of all apartment home providers and worse, undermine the sense of home that our residents deserve. Many of these residents are vulnerable and without the resources to seek alternate places to live. We continue to support any legislation that incentivizes or reduces barriers to development and holds housing providers accountable so we can increase housing for all income levels. None of these bills before us today address the desperate need to increase our housing supply. Thank you for the opportunity to testify. I welcome any feedback or questions.
Thank you, Ms. Miller. Any questions or comments from members of the committee? Seeing none, we thank you for sticking it out with us. I know you were here for a number of hours before you went home. Next
Same
is
to
number
you all.
100, James Blau. I hope I'm saying that right.
That is correct. Thank you. And yeah, I didn't think I would be up this late. Thank you all committee members for giving me this opportunity and everyone else who's had an opportunity to speak today. My name is James Blau. I'm a resident of New Haven, and I'm here to speak in support of House Bill 6889. And this is partly due to personal reasons. So in February of last year, I was displaced from my home of 12 years, which was in a 19-unit building in downtown New Haven, due to catastrophic maintenance issues that, following years of neglect, had finally rendered my apartment unsafe to live in. When I protested this situation and was joined by my neighbors in forming a tenants union to also address other maintenance issues in the building, our landlord responded first by selling the building, and then the new landlord forced everyone out through non-renewals. Had this just cause expansion bill passed in the last legislative session last year, it probably would have saved our building. Some of my neighbors in that building had lived there for 30 years. Instead, the building, one of the last affordable rental buildings in downtown New Haven, is currently sitting empty while the landlord is busy converting it into luxury rentals. Given the current market for such rentals, we can expect 1-bedrooms in the renovated building to rent for $2,500 or more, and 2-bedrooms for $3,500 or more. Some speakers today have suggested that adequate tenant protections from such outcomes are already in place and that therefore this bill is not needed. I believe that my experience, along with the many others recounted here today, conclusively shows that assertion to be untrue. So I ask the committee, please listen to the truth of my experience and the experiences of all the other tenants who've testified here today about similar experiences. And please listen to all the advocates who've come here today to tell you about people and statistics about people in similar situations who've had very similar experiences. This is not a minor issue. This is affecting thousands of people. This housing insecurity issue that I've faced and that we've been discussing all day, all morning and all day yesterday, is not a minor issue. This bill can help alleviate that issue. It can help protect tenants who complain about maintenance issues from retaliatory evictions. It can help protect tenants who file fair rent commission complaints from retaliatory evictions. It can help protect tenants who pursue municipal housing code enforcement from retaliatory evictions. It can help protect tenants who form tenants unions from retaliatory evictions. Contrary to an assertion made as part of recent testimony, it should also protect tenants who talk to journalists about their landlords from retaliatory evictions. It will also prevent landlords from refusing to renew leases just because they know they can charge the next tenant substantially more, thereby contributing to our statewide storage.
Summarize. Thank you.
Absolutely. Thereby contributing to our statewide scourge of rent inflation. I believe this bill will improve social stability, reduce housing insecurity, and help to stem the tide of runaway rent inflation. It should be able to provide substantial and much needed help to some of the most vulnerable and hardworking people in our state. Thank you.
Thank you, Mr. Blau. I don't see any questions, so I'll just say thank you for your stick-to-itiveness and your passion and sticking it out with us all these hours. Next is John Souza, number 202.
Greetings, everyone. Co-chairs Marks and Felipe, appreciate your time. Ranking member Scott and Sampson, I appreciate you guys staying up late. My name is John Souza. I'm a longtime landlord. I also volunteer as president of the Connecticut Coalition of Property Owners. We've been involved with up at the state capitol for many years. Our members are small and mid-sized landlords that are local, mom and pop operations, if you will. Most are more than just 1 to 4 units. Most have other size buildings and more than just 1 or 2, but lots of them have just a side-by-side 2-family or something, and they live in a unit. So we represent the people that you want as your landlord. Most of our landlords are good landlords, are the people that hopefully you would get an apartment from and stay for a long time, because I like it when tenants stay for the most part. I do have some comments on some of the bills tonight. I've heard a lot of stuff. I've been listening as much as I can today. Some things that I haven't heard, and I'm going to mention 6889, lapse of time eviction. We've heard a lot of stuff about it, the way it's used. I would like to point out a couple things. As of last year, the lapse of time can be erased when it's withdrawn. So a lot of the people use that and then they erase the record from the public records. I think that's a good thing. You know, landlords and tenants aren't always going to get along. Everyone says they just get thrown out for no reasons, you know, and they just want more money. But a lot of times there are issues, and when you use that, if you get rid of that, you won't have any other way to leave peacefully between each other. And you know, I rent to people that have been evicted for lapse of time. In fact, in Hartford in the West End, a couple of these people you're talking about came in, took over a building, and 2 or 3 of the tenants came because we had an empty apartment. I ended up renting to a couple of them. I did check. I wanted to make sure it was because of what they told. But I'd also like to mention that this bill doesn't just get rid of the lapse of time portion of it. It actually gets rid of 5 different reasons that you could ask somebody to leave, including nuisance, severe nuisance, which would be like somebody attacking your manager or attacking other tenants, which does happen. And it's a fast track so that they don't have to wait around where they can assault people. But more importantly, there's non-landlord tenant reasons that this actually comes up, and squatters is one of them. If you go away on vacation for a month, or you go to help your kid who had a baby for a month, you come home, there's somebody living in your house. You didn't rent to them. There's no agreement. That's a non-landlord tenant obligation between each other. And what happens is if they took out the clause where you could get rid of them. It's the one that you never had a right or privilege to occupy the place. Otherwise, I have no term to get them out of my house. They say they have a lease and they live there. So you know, it would be ridiculous. The second half of that thing, which is formerly had a right and no longer has a right, that would be in the case of like a foreclosure, and the person that lived there was the owner and they're still in the property. The bank wants them out. They used to have a reason to live there. They used to have the right to live there, but it's expired and it's terminated. So without that clause, there's no way for the bank to get them out because they're not going to collect rent from the person that didn't pay the mortgage. So they would be stuck there with that person in there. These are the kind of things that they don't think about before they write these things. And I don't understand why they would want to get rid of them. These have nothing to do with throwing people out so that you can quote unquote raise the rent.
Expired. If you can please summarize. Thank you.
Secondly, I have a lot of testimony. I'd like to, you guys can look at it, but our biggest problem is, and we all agree to this, is if we don't build more housing, you're never going to solve any of these problems. Because if somebody can just leave and go up the street and find a much, you know, a comparable house at a reasonable price, then, you know, nothing's going to get solved. We're playing musical chairs, really. There's 10 chairs and 12 people looking for a seat. And until that gets solved, you can't solve any of these problems. So please work on making it easier to build, making it more advantageous to build. Don't take away the rights, make it easier to build. In fact, all the people out there that, you know, all these organizations, there's a lot of brain power. There's good people. Start building properties. You know, the churches, all these people, why aren't you guys building properties? There's grants out there. You could put a little bit of your money into it and maybe make a little profit, and then you could put the profit into the next property. This is how these problems are going to get solved. We all work together. I want to work with these people. I'm happy to work with these people, but you can't keep chiseling away the landlord's rights every year, a little at a time. It makes it harder and harder. And quite frankly, guys like me want to sell out. I'm 25. I've been in this for 35 years almost. I'm a good landlord. I know my tenants by name for the most part. Yes, I get rid of people once in a while when they don't pay or they're trouble, but you know, I don't want to do this. I don't want to keep fighting year after year after year with less rights, you know. And some of the things you do hurt the tenants in the long run. I'm sorry, but it does. You know, the 1 month's rent thing. What do you think's going to happen? They're not going to pay the last month's rent, and then there's a $250 charge they do with some damages and some paint. Normally, I would take it right out of their security and send them back the difference. But now it goes on their credit and it hurts them, right? Their credit is dinged.
Sorry, Mr. Souza, we muted you because we told you your time had expired. We were trying to get to the end of the thing. I'm just going to say one thing. I need to make this clear because I think 2 people have said it already. And maybe it's a way that we wrote the bill. So if we need to talk about it offline, we can. but nuisance and I think what you called serious nuisance, those are two things that are causes under just cause eviction. So we can have a conversation of why that is not being seen by folks, but those are two things that are causes. We're not getting rid of nuisance. That is not our intent. And if that is what the bill currently says, in your opinion, we will find a way to write it better. But thank you, and we appreciate your time. Next is number 204, Caroline Austin.
Good morning. Are you able to hear me?
Yes, floor is yours.
Thank you. Good morning, representing members of the Housing Committee, members and existing folk. My name is Caroline Austin. I've lived and worked in the Asylum Hill neighborhood of Hartford, Connecticut for the last 16 years. I'm a single mother of 3, a 30-year-old that no longer lives with me, a 21-year-old college student, and a 16-year-old high school junior. I am speaking today in testimony of in support of HB 6941, the income waiver for young working adults in RAP households, something that I haven't heard many people or think anybody speak of. And I've been on since 10:30. So I'm a dedicated parent, leader consultant, a member of the 2 Gen Advisory Board, and represent my community as a member of the Early Childhood Cabinet, among other committees and boards, both in and outside of the state. Along with my deep commitment, I'm also a recipient of Section 8 housing who lives and works with a disability. Today, I'm here to express my strong support for HB 6941, which seeks to implement an income waiver for young adults ages 18 to 26 living in rental assistance protection units. When my son was still living with me and working, his income caused my rent to increase significantly, making it incredibly difficult for us to make ends meet. He was doing what any young adult should do, trying to save and gain independence and move out on his own. But instead of me being able to support him in that transition, his financial obligation due to his salary and the increased rent made it impossible for him to adequately save while also contributing to our household. He left so as not to cause additional financial strain while he was working it out on his own. He ended up living in his car for a while, and that was during COVID. That was right when COVID hit. Thankfully, he is through that, and we've made it through that. Now my 21-year-old is in college and facing a similar risk and is having the same concerns. She's taking the initiative to work and fund part of her education and her future. Yet she is constantly, weighing how much she cannot work without putting our household at risk. She understands that earning more would mean that our rent will rise to an amount that we cannot sustain. As a mother, I try to do everything I can to support her. However, I do have another child in high school that depends on me financially. Within the last 2 years, my rent has increased by $475. I love my job, but it doesn't pay me enough to fully meet my family's needs, so I'm seeking an additional job that will pay more. So I do risk losing Section 8 assistance entirely, facing the benefits cliff where I will be unable to afford my rent and essential expenses. Even with my daughter's income, this could also put her in a position.
Have expired. If you can please summarize. Thank you.
Okay, thank you. So where she would have to work full time and go to school full time with no guarantee that we would be able to afford the living situation. So this is the reality basically for many families. Young adults like my children are striving for independence, yet their income is counted in a way that could destabilize families and like my own, rather than supporting their growth. The current system discourages work, savings, and financial progress, keeping our families trapped in a cycle of dependency rather than lifting them up to self-sufficiency. A simple income waiver for young adults in RAP households would prevent unnecessary and financial hardship, allowing families to maintain stability while fostering long-term economic mobility. So I urge you to consider passing HB 6941. I just thank you so much for all of the work that you're doing and for everyone that has lasted from early this morning to late tonight. I wish everyone a good night. Safe travel home.
Thank you, Ms. Austin. We appreciate it. I don't see any questions, so thank you for sticking out with us. Next is Peter Harrison.
Good morning. Can everybody hear me okay?
Yes, sir. Floor is yours.
All right. Thank you, members of the committee, for sticking up in there. This is not going to be as articulate as it might have been about 14 hours ago, but I'll do my best. My name is Pete Harrison, and I'm the Connecticut Director of the Regional Plan Association, which is a tri-state nonprofit dedicated to research, planning, and advocacy. We oversee the Desegregate CT program, and part of our approach to solving the housing shortage in Connecticut is what we call this all the above approach. And primarily, we support land use reform at the local and state level to address the significant amount of underproduction we've had at a state, which has been discussed directly and indirectly over the course of today's hearing in terms of being one of the most constrained rental markets in Connecticut. So as part of that all the above approach, we also want to impact upstream and downstream. And because there is a significant amount of underproduction in housing because of exclusionary zoning policies, we also support things like 6889, the Just Cause, and also additionally the Right to Counsel funding. We recognize that there is a significant imbalance in the housing market today that is showing itself specifically because of a lack of rental market housing. So we believe Just Cause is a completely reasonable additional protection for a specific set of circumstances. As others have said, this is roughly between 7% or 11% of eviction filings across the state. And specifically, we believe that this gives additional protections for tenants that do face an imbalance in the housing market that may wish to address specific shortcomings from a landlord or unsafe conditions. But importantly, and I appreciate the previous landlord who just testified, and there might be some needs for revisions in some of the language to clarify this, that this is not an end of evictions for cause. It is specifically to require cause and to give a certain expectation for landlords and tenants going into an agreement to protect them from concerns about loss of rights over the course of that first year. So we think this is an incredibly reasonable additional protection. We, however, think that this committee and this body should focus on overall the increase in production of housing really at all levels of income, to own and to rent. And certainly our priority this session is work with RIDE, which is we believe will help do that. It's not one thing that's going to solve the housing shortage. It's a number of interventions across the market. And we believe that at this time, Just Cause is one of those reasonable.
Thank you.
Yeah, and just in conclusion, we think this is an infinitely reasonable protection in this climate and support Just Cause eviction this session. Thank you.
Thank you, Pete. Any questions from members of the committee? Seeing none, we thank you for sticking it out, and it was plenty coherent. I'll let you know. Let's go to 208, Sarah Locke. Nice to see you, Sarah.
Thank you. Thank you so much, Representative Philippe and Co-Chair Marks and members of the Housing Committee. My name is Sarah Locke. I live in Oxford, Connecticut, which is part of the Naugatuck Valley. I'm part of the All In Alliances, and I'm here to speak in support of House Bill 6889, an act concerning evictions for cause. Housing's been on my mind for years. First, it was as a new homeowner when we bought our house with a CHFA mortgage. Now it's as an aging homeowner and parent to 3 adult children. 2 of my adult children are disabled with significant medical and neurological concerns. All 3 have strong cognitive ability and do not qualify for assistance from DDS. Those details might sound off the subject, but it has everything to do with housing. Young adults without disabilities have difficulty finding and keeping housing they can afford, never mind the wait lists and lack of subsidized housing for those surviving on SSI. My dream is to have each of my children living as independently as possible before I'm gone. That dream, as modest as it is unlikely to come true unless something changes. House Bill 6889 is not just about tenant protections. It has the potential to make a difference in the overall housing market here in Connecticut. By protecting my neighbors who live in rental housing of 5 or more units, this bill enables those neighbors to protect the units that they live in from predatory, large-scale landlords that view their homes as nothing more than an investment. But that corporation's investment is my neighbor's home, their safe place, the place where they can unmask from meeting the expectations of employers, coworkers, and strangers, a place where they can exhale. Someday, it may be the place my son or daughter could call home. This home should also be the place where they can report concerns and needed maintenance to the landlord, where the landlord responds because he knows the value of a good tenant. Right now, landlords, especially corporate landlords, have the upper hand. It's relatively easy for them to find a tenant who will accept a much higher rent for the same apartment. With only a 7% vacancy rate, there simply isn't an option of moving to a different apartment when landlords fail to make needed repairs or address safety concerns. There's been a long overdue push to create more affordable homes in Connecticut. However, as new homes are built, existing homes are lost due to price gouging, negligence, and neglect. The stock of affordable housing decreases as regular working people are evicted in favor of wealthier people who can pay much more. It's like pouring water into a leaky bucket. The bucket never gets full and people are getting wet. House Bill 6889 can slow the loss of affordable, attainable homes. It can protect these homes from negligence and decay. It also protects whole buildings from being cleared of tenants just so a wealthier class of tenants can move in. It protects the rights of good, stable tenants that contribute to stable communities and schools. This bill does not fix the housing problem, but it is a good step in that direction. I urge you to support House Bill 6889.
Thank you, Sarah. I don't see any questions, so we're just gonna say thank you for your passion and for sticking it out with us. And it is Representative Felipe. The second E is not silent. Just reminding folks. Next, we have 221, Rosanna Ferraro.
Good morning, Housing Committee. I'm Rosanna Ferraro. I'm the Policy Director at Universal Healthcare Foundation of Connecticut. I'm here in support of the same bill that Carolyn Austin was here for. I was very glad to hear her speak of it, not necessarily glad for her circumstances, so to speak. House Bill 6941, it would exempt a child's income in consideration of a rental assistance application. It may be the hour, but I was going to come with very technical explanations of what a benefits cliff is and all of these pieces. But ultimately, I realized that a woman who wanted to be here this evening, I think the hour grew too late, is someone I work very closely with. And she was extremely passionate about this issue and really has opened my eyes in my work with her about what the consequences really are of considering a child's income, like Carolyn was speaking about, when they get older and do the responsible thing. And it's ultimately, I think, this issue comes down to an access to work. We want our young people to be able to work, to learn those skills, and to be able to earn their own income. But it is only when a child's parent has a low income that we are putting this burden of some of their pay going to contribute to the household. Because if they're counting the income, it's expected to contribute to the household. This is not something that middle class or upper class children necessarily have to do. So I see this as sort of disproportionately impacting low income folks, and we know that often is our Black and brown communities. I won't belabor the point. I just want to thank the committee for raising this bill. It is a incredibly great first step. And to be perfectly honest, when I saw that y'all were hearing this bill, I was a little emotional because this issue is near and dear to my heart, but also near and dear to the heart of many people that I work with in community, in which I have the honor of doing. Thank you all so much. Have a lovely day, and I absolutely hope you get some rest.
Thank you. And just very quickly, I have one question. It's just because we haven't spoken about this specific issue many times today. It's just people have talked about the income limits and in a way of having a limit as well for how much income a minor could make in this instance. Would you have an adverse reaction? I'm sorry that I'm taking long to get to the question. To maybe somebody between the ages of, let's say, 18 and 24 being disqualified if they make more money than the principal resident does? Is that something that you would be agreeable to?
I understand what the question is getting at, as far as what if somebody, what if a child is making so much money, right? I think we could maybe, instead of measuring it up against a parent, the parent or the applicant on the rental assistance, maybe look at more of an overall limit according to, I wouldn't necessarily want to put a numerical value on that, because we know that that loses value over time. I think some 200, 300, 400% of the federal poverty level feels reasonable. I would actually have to run numbers, and also, to be 100% transparent, I'd also would want folks in community to have a little input on what feels reasonable to them. And I actually work with a coalition of groups. We call ourselves the Benefits Cliff Work Group, and we'd be more than happy to meet with any of you on this issue to maybe work out, like, if there should be a limit, what that could be.
But within those parameters, and just yes or no really quickly, you'd be okay with a limit of some sort?
I understand why we would need a limit. It would depend on what that limit is.
Thank you very much. Appreciate the time. No other questions from members of the committee. Enjoy the rest of your morning. Next, we will get to 217, Sarah Giovanniello. Hope I got that right.
Hi. Sorry, I look a mess, guys. I just woke up, so bear with me. Good evening, Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Sarah Giovanniello, and I'm a resident of New Haven, Vice President of Blake Street Tenants Union, and a Chapter VP of CTTU. And I'm testifying in support of HB 6889. My landlord, Ocean Management, tried to use lapse of time evictions to bully residents into accepting unreasonable rent increases in 2023. And fortunately, we were able to fight back and come to an agreement. My comrade Jessica Stamp spoke at length earlier about this, so I'm not going to rehash it. But I do have some other comments. I haven't listened to this whole hearing. I just took a break for a few hours. But the somewhat hysterical tone with which landlords have been talking about this bill is very puzzling to me. Because we are talking about expanding a law that already exists that would only affect buildings that it already affects. So I live in a 70-unit building. There are already many residents in my building who have this protection, disabled people and those over 62. And during our eviction fight, those tenants were also able to negotiate a fair rent for their situations and sign a 2.5-year lease with my landlord. The difference was that Ocean could not evict them as easily. And so the Fair Rent Commission could have had the last word on whether my landlord's proposed rent increase was reasonable had we not been able to come to an agreement with the landlord. No tenant in the state of Connecticut, whether protected from no-fault evictions or not, has the right to refuse a reasonable rent increase. So the only reasons that this bill would be a problem for landlords, if you ask me, is if they want to implement an unreasonable rent increase, they want to retaliate against a tenant, or if they wanted hypothetically to avoid having to appear before the Fair Rent Commission, which actually is common. So let's call it what it is, right? And then on the point that people are making about renovations, point that people have been making. I'm sorry, I'm still asleep. Mass eviction to renovate sends working class Connecticut residents down a path of housing insecurity that can be traumatizing or deadly. If you want to renovate, relocate the tenant. My landlord spent $12 million in our building when he bought it, a $9 million mortgage and a $3 million bridge loan to renovate it. We recently got the building appraised at $7.9 million after he did those renovations. He bought it for way too much money and he almost went into foreclosure. I think if you gamble on mass eviction from a large building in Connecticut to make a profit, you should lose that gamble. I think that's a much better message to send out to out-of-state speculators than if you come here and mass evict people, you can make a lot of money.
Daniela, your 3 minutes have expired. Please summarize.
Excellent, I will. Landlords aren't the only people who want a lease. Tenants also want a lease. It gives us stability. We can plan for the future. The power dynamic that has been created by corporate landlords gambling on our housing, like the stock market, is untenable for CT renters. Connecticut renters. Losing your home and losing your profit margin are not the same thing. Thank you for staying up so long. I welcome any questions.
Thank you. I don't see any questions from members of the committee. Thank you for sticking it out with us and jumping back in. Next is 214, Elias Estabrook.
Thank you, Representative Felipe, Senator Marks, and other members of the committee. My name is Elias Estabrook. I also live in New Haven. I'm a member of New Haven Rising, and I also serve in our city as a volunteer on our Affordable Housing Commission. I've been on that commission for 4 years. So I'm familiar with a lot of the overall challenges we have in terms of affordable housing. I'm also a tenant, and I'm here testifying in support of HB 6889. And I believe all tenants should have just cause eviction protection. I've seen from different hats that I've worn that people can't get ahead in any area of their lives without a safe, stable place to live. In addition to being a tenant for several years here, I've been a workforce development job coach. I, for about a year, have been an assistant instructor in our schools as well, seeing, the effect on students. And myself, I remember what it was like to pay about 50% of my monthly income for rent while I was on a month-to-month lease here in New Haven, 2016 and 2017. And thousands of Connecticut families are living with tremendous housing cost burden and supporting their families. And I think the cost of moving after an eviction and paying a security deposit at a different home is an additional burden that most really can't afford, especially on very short notice. So for myself, finding an affordable home when rents really went up during the pandemic, 2020, 2021, was challenging. And my partner and I, although we dream of living in our own home, our own apartment, we moved into a room in a house with 2 other roommates where we are now. And it's affordable right now, but we have a month-to-month lease, and our rent went up by $300 about a year ago. So, I'm holding up my end of the lease to try to keep my housing stable, like many tenants in Connecticut. And I know you all have heard a lot about housing stability, and I just want to echo that I think that's really critical for our neighborhoods and for young people. So myself, I only moved once while I was in elementary and high school, and it was a move that my parents chose to make our lives better. I was in 5th grade. I got to stay in the same school, even moved closer to that school, and it was hard for a few days. I remember being sort of like emotionally trying to adapt to a new place on a new street, but I really thrived after that. But I think on the other hand, children in lower income households, they tend to be more likely to move more often than that, even involuntarily. And I think that's not right. And it's really affecting many children in our state negatively.
Have expired. If you can please summarize. Thank you.
Sure. Yeah. So I think there is more we can do in our state to address getting more affordable housing supply, but that's going to take time and money to do. But I think in the meantime, this is a reform that really could help a lot of renters, and so I support expanding just cause eviction protection. Thank you all for your attention this whole evening and morning.
Thank you, Mr. Estabrook. I don't see any questions. Thank you for joining us and sticking it out. Next, I want to go to Jennifer Paradis, and I just want to let everybody know the next person is 222. If you are a number before 222 and you end up signing on after right now, you're gonna have to wait till the end. We will get to you, but we will go through the 200s before we get to the next folks. Jennifer Paradis, floor is yours.
Good morning. Believe me, I know what kind of grace that is, and I appreciate that so much. Good morning, Representative Felipe, Ranking Member Sampson and Scott, and members of the Housing Committee. My name is Jennifer Paradis. I live in Hamden, Connecticut, and I'm the Executive Director of the Bethel Center in Milford, an All-In Alliance partner and a board member of the Connecticut Coalition to End Homelessness. I'm here in support of HB 6889 and HB 6948. At the Bethel Center, we serve hundreds of households experiencing homelessness or at risk of homelessness. We do that through outreach services, emergency shelter services, permanent supportive housing, food services, and community engagement projects like our Landlord Engagement Network and Tenant Certification course. At Bethel, we work together with all of our community stakeholders to create stable, trusting, long-standing relationships between landlords and tenants. However, there is a large difference between the number of people we can house stably and the number of people becoming homeless and at risk of homelessness every day. Last year, Bethel served nearly 1,000 households in our homeless prevention services. These are all households that were either homeless at the time of their assessment or have a notice to quit and pending eviction. Of these households, nearly 80% reported to their navigator that the reason for their homelessness is because their expenses exceeded their income, and many were impacted by the no-cause evictions or end-of-time lapses that we are talking about here, and forced to leave their homes with no option other than to try to access homeless services through an already stretched and overburdened homeless response system. Sadly, there is a direct pipeline between what we're talking about today and homelessness. Expanding just cause protections is necessary to stem the increase in homelessness for folks who should never have experienced such a traumatic event in the first place. They are most impacting our older adults, our seniors, and our children. Additionally, I spend much of my time in the 13 communities Bethel serves, including the lower Naugatuck Valley and the Milford-Guilford shoreline. In these communities, I speak with homeowners who can see the degradation of our communities. Naturally affordable housing was the historic apartment building. It was the beach bungalow or the downtown on Main Street with business apartments that have, or the downtown Main Street apartment with the apartment above the business. But many are being sold to private equity firms, and housing is being built under the guise of much needed density and housing availability, but is really luxury housing units too costly and therefore inaccessible to the people who live and work in that community. The people of Connecticut want to ensure a stable rental market that fosters community through a long-term tenancy, prevents communities from losing more of the reasonable price rental market of which we've come to rely. This will be accomplished with expanded just cause laws.
Summarize. Thank you.
I will, as and was done when first established decades ago. Lastly, I ask you to support 6948. In 2020, CCEH did a data match of 450,000 people who had been admitted to the DOC, the state's joint prison and jail system, and 17,206 were who were in shelter at the time. Nearly half who used homeless shelters were formerly incarcerated. 1 in 5 people who used homeless shelters had been released from prison in the past 3 years. This is a debilitating relationship due to the barriers associated with housing for those with a criminal record and criminalization of homelessness. Thank you so much for your time tonight.
Thank you for joining us. I don't see any questions, so I appreciate you sticking it out. Next we have Michael Matavu.
Hello. Hi. Co-chair representative, my name is Michael, co-chair representative Felipe and co-chair Senator Marks, members of the Housing Committee. My name is Michael Matovu. I live in Seymour, Connecticut, and I am a member of the All In for Seymour organization. And I am here to speak in support of House Bill 6889. Having housing is one thing, but being secure in your housing is another. We live in a state where an individual can be an on-time rent-paying tenant and still not be secure in their housing for a plethora of reasons. Reasons a tenant has no control over. Housing insecurity and affordability issues have historically been issues reserved for people who lived in economically disadvantaged areas, those people being Black and brown people. But we're at a point in time where housing affordability and security is an issue starting to affect middle class indirectly. Starting to affect the middle class indirectly and directly. So I mentioned before, I live in Seymour, a town made up of a hardworking, dwindling middle class people. Emphasis on dwindling, where the area median income is over 100,000. And in my work with All In for Seymour, I've had the privilege of talking to people past retirement age who, after years of living in a big house with the kids they have raised into young adults who are now at the age to move out, are looking to downsize. But they can't. Those folks simply just can't afford to downsize. But that's just another issue I hope we can tackle in the future. But for now, I'd like to talk about the young adults who now work and make just enough to move out, but due to housing insecurity and affordability are now forced to move back in with their parents. Sorry. I talked to a person a little younger than me who luckily found a job out of college that was paying him well over 60K. I think it was well over 60K. But even with making that much, he was still a cost burden renter. But he stayed in his apartment because the freedom he felt living by himself was greater than the thought of moving back in with his strict parents. He then told me one day his landlord decided to increase the rent out of nowhere. Knowing he couldn't afford the rent increase, he felt he had no other choice but to move back in with his parents. His story is but a drop in a bucket of people suffering from the same issues, probably even worse. He had a family to fall back to. What of the people with no other family to fall back to? Where do they go? We're living in times right now where the inflation of rent prices coupled with the inability to afford basically anything in Connecticut will cause people to leave the state of Connecticut in droves. And for the people who aren't able to leave, those people will be faced with homelessness. So until we can get the housing crisis in check, I believe the Just Cause bill is a Band-Aid to help people be secure in their housing, safeguarding them from just cause evictions and homelessness. And also thank you for your time. Have a good morning and good night.
Thank you, Michael. We appreciate it.
No problem.
Next, we have Joelle Fishman, 225.
Good morning, chairs and members of the Housing Committee. My name is Joelle Fishman. I live in New Haven. I'm really proud to be here today. It's been a long day as part of the huge outpouring of renters from across our state demanding an expansion of protections. And I know that you're listening carefully, but please hear these courageous voices. The housing crisis is a crisis for all, except the mega landlords who are driving it in my city and across Connecticut. I'm representing the Connecticut Communist Party, and I'm also part of the Connecticut for All coalition in support of the equity agenda, which includes expansion of just cause protections. I'm speaking in support of HB 6889, an act concerning evictions for cause as urgent to enact this session, especially given the situation in our country today. Post-pandemic, profits are soaring for the few, but most families are paying over half of their income for housing and live in economic insecurity. When a landlord refuses to renew a lease at whim, offering no justifiable reason, that family is at risk of becoming homeless. Just cause eviction protections have been proven to significantly reduce evictions in the 5 states and 12 cities where it's been enacted. Housing should be a human right for the well-being of the individual, for the well-being of the community, and the economy. The objection is raised, there should be no oversight on landlords. But just as measures are in place to oversight utilities like electric, gas, and water, it's common sense that requirements should be expected of landlords who control housing. As a renter for most of my life, I know the uncertainty and devastation that comes with a landlord's power to terminate a lease at will for no reason. It upends everything, impacts children's education, that was my own, ability to get work, that was my dad, and ability to plan for the future. HB 6889 is a common sense part of the solution to the housing crisis. It expands existing law that covers seniors and those with disabilities. Expanding just cause eviction protection will provide immediate security to all renters and therefore strengthen our communities as a result. Expanding just cause eviction protection is also a step toward racial equity. The housing crisis is disproportionately hurting
Three
people.
minutes have expired. If you can please summarize. Thank you.
So I want to give appreciation to this committee for the actions around fair rent commissions in our state are so important. And I want to give a lot of appreciation and recognition to the Connecticut Tenants Union, which is teaching renters to organize for their rights, to maintain dignity and respect by acting collectively. And in this national climate, it's so important this session to pass HB 6889 for stability and security that benefit everyone. Housing is a human right, and thank you.
Thank you, and thank you for sticking it out with us and staying up to this late hour. Next, we're gonna have Richard Cooper, followed by David Parisier, followed by Jim Paris.
Let's see. Video stopped. Hi, everyone. I'm sorry if I don't have my video available. I'm not sure I'm going to be able to quickly fix that. And oh, wait, here we go. Here we go. Okay, hi. So I know it's good morning, members of the Housing Committee. I'm going to be very quick because I thank you all for being here. I come before you not as a tenant or a landlord, but simply as someone who believes in HB 6889. I think it strikes a balance between protecting tenants from arbitrary evictions while also ensuring that landlords are not subject to unreasonable restrictions. That's all I have. Thank you for your time.
Thank you, and thank you for being quick and on time. We really appreciate it. Next, we have David Parisier. I hope I'm saying that right.
Representative Felipe, you absolutely did. Good morning, and kudos to everybody who's been hanging in here all day and all morning. I'm a member of CTA and Principal Paradigm Partners. We provide homes to thousands of Connecticut residents, and having been a renter myself in the past, absolutely agree that that the rights of renters and the rights of landlords are incredibly important and need to be weighed at all times. I'm here to voice opposition to HB 6889, specifically in several other bills, but 6889 is what I'm going to dwell on, which is the evictions for cause bill. There are numerous rights that tenants have already in terms of evictions for cause. Landlords do not use it frequently, which is a fact. Landlords use it as a last resort, and it also basically verifies and validates the contract between tenants and landlords, which is the lease. and the lease has a date and an end date. And that is really what we all have to hinge upon. It also protects other residents from unruly, dangerous, and residents who don't obey the rules of the lease and don't respect the other residents' privacy and take other residents' rights into their own sorry, it's very early in the morning, who violate the lease in itself. We have numerous cases within our buildings and our portfolio where we have to protect other residents from residents using lapse of time. And it is an important tool of the landlord, and it's an important tool for protecting residents. The other bills which have come up, 1302, and also 6943, we are in opposition to these, as well as 6891, which also makes it more difficult for residents who are good people but have difficult backgrounds to get rentals. We always want to rent to people. We don't rent to money, we rent to people. And if we can make that person more acceptable through financial means or by helping them with the application process, we will. The last one is 6892. That is one where we think that that's going to disincentivize people from buying investment housing and also from creating more housing. The point is to create more housing in Connecticut. The point is to create more affordable housing. These new regulations and laws that are being discussed and discussed year in, year out will not create more affordable housing, and they will not create better housing for Connecticut.
If you could please summarize. Thank you.
Yes, of course. But that's what we're here to talk about. Connecticut Apartment Association and the landlords of Connecticut who are offering and make their livelihoods offering and creating good housing for the residents and the people of Connecticut will be damaged by these laws, and the housing stock of Connecticut will be damaged by these laws, and there will be less affordable housing, there will be less investment in housing. And the whole goal of Connecticut Apartment Association, all of us owners and managers that are responsible providers of housing, is to create more housing, not less. So we urge you to create more housing, not less, through these bills. Thank you, and thanks for your unbelievable stalwart and patience through this process.
Thank you, Mr. Brizier. We really appreciate you. I don't see any questions from members. I'm just going to make a quick comment and no need to respond. But nuisance and breach of lease are two things that we've heard from a few people. Those are both causes under just cause eviction, just as a clarification. Next, we have number 227, Jim Paris from Home Builders. Nice to see you, sir.
Good morning, Chairman Felipe and Chairwoman Marks and distinguished members of the Housing Committee. Thank you for the opportunity to testify. My name is Jim Paris, and I'm here on behalf of the Home Builders and Modelers Association of Connecticut, representing nearly 900 businesses across the state. Connecticut's in the midst of a severe housing crisis. Homeownership is increasingly out of reach for young families and middle-class workers, and rents continue to rise due to lack of supply. We must be thoughtful in our policies to encourage, not hinder, new housing production. The HBRA supports Senate Bill 1307, an act establishing a working group to study and develop best practices to promote housing growth and protect the state water supply. But we recommend amendments. The bill's intent to balance housing growth with water supply protections is important. However, current water utility practices, including excessive hookup fees and inconsistent regulations, drive up the costs of development, and we urge that the working group be tasked with developing a builder's bill of rights, which would help establish a clear and consistent standard, reducing unnecessary costs and ultimately making housing less affordable. The HBRA also opposes House Bill 6889, which would create new lapse of time removal restrictions. We recognize the need for tenant protections. This bill would discourage investment in new housing at a time when we desperately need more supply. Instead, we urged the committee to focus on policies that increase housing production, such as streamlining permitting, offering tax incentives for new construction, and supporting adaptive reuse of existing buildings. Finally, we support Senate Bill 1308, an act establishing a starter homes working group, and we thank Senator Marks for her leadership on this bill. Senate Bill 1308 would establish a working group to advance the development of starter homes. For too long, Connecticut has made it nearly impossible to build affordable entry-level homes without heavy subsidies. This has locked out young buyers, young families and first-time home buyers, increasing demand for rental housing and driving up costs across the board. We look forward to participating in this working group and help create viable solutions for Connecticut's housing future. In closing, Connecticut needs policies that expand housing opportunities, not ones that create additional barriers to development. We urge the committee to amend Senate Bill 1307 and to explicitly include recommendations for a Builders' Bill of Rights to control costs, reject House Bill 6899 to avoid discouraging investment, and advance Senate Bill 1308 to support homeownership opportunities. Thank you for your time.
Thank you, Mr. Paris. We appreciate you coming before us, and I want to make an unofficial policy change for the committee and say that nobody has to apologize when they make a mistake at 3 o'clock in the morning.
Much appreciated. Thank you.
Next, we have number 245, Ramon Garcia.
Oh, excuse me 1 second. Good morning. Greetings, Representative Felipe, Senator Marks, ranking members, and other esteemed members of this committee. My name is Ramon Garcia. I'm a lifelong resident of Connecticut, and I'm here to testify in support of House Bills 6892, 6889, and 6948. Housing is one of the most basic human necessities, and the issue of housing insecurity and homelessness is a major crisis in our state, which only seems to be getting worse. This is not a battle between property owners and tenants. Rather, it's a matter between right and wrong, and ultimately where your humanity lies. Not every property owner is a foul actor, and not every tenant is a good tenant. And regardless of whom or where any abuse or injustice permeates from, it should be addressed fairly on all ends. There has to be a balance, and I believe that the passing of these bills 6892, 6889, and 6948 is a step in the right direction. We mustn't allow greed to overtake us, nor allow biases and prejudices to prevent us from being just towards others. Currently, I work at a shelter here in the city of Hartford, which serves a wide range of people from diverse backgrounds, both men and women, young and older, and they all have a story. And frankly, none of them want to be without a home, never mind in the freezing cold. So I personally have experienced housing insecurity and denied a fair chance at a housing opportunity solely due to a past involvement with the legal system. During this time, I had worked 2 jobs, which was advocating for a better educational system for all students in Connecticut and working with at-risk youth in a number of schools. Yet, in spite of all this, I was still denied the opportunity for housing. Consequently, my kids suffered, in addition to the negative impact it had on my overall well-being. I speak on behalf of the many unhoused people here in our state and those at risk of losing their homes without just cause or due to exorbitant rent hikes. And it is my hope that as leaders of our state and simply as human beings, that you will fight to end and prevent this needless suffering. For without a home, everything else falls apart. Thank you for your time. Enjoy your morning.
Thank you, Mr. Garcia, and we hope you enjoy your morning as well.
Thank you.
Next is number 224, Hillary Desideraggio. Hope I said that right.
Good morning. You did say that right. Good job. Senator Marks, Representative Felipe, and members of the Housing Committee. My name is Hilary DeSotoraggio. I'm a resident and homeowner in New Britain, and I support HB 6889, an act considering evictions for cause, and believe all tenants should have just cause eviction protection, as well as HB 6892, an act limiting the increase of rental charges upon transfer of residential property to a new owner. These two bills working together can do a lot to protect tenants of Connecticut. One makes sure that tenants don't unfairly get kicked out of their home. The other makes sure that tenants don't unfairly get really high raised rents when they get a new owner, which has been happening more and more recently, especially recently happened in my own city of New Britain, in a complex called the Ellis Complex. A lot of people had their, you heard someone talk about this earlier, but a lot of people had their homes taken away from them because they had a new owner that jacked up the price literally double in many cases, because it used to be income based, which is just scary. Anyways, I'm going to refrain from giving you a lot of facts and figures because I know that there are many housing experts who have already submitted their testimony, either orally or written, and they have that information. This is instead a call to humanity by a community member who loves her neighbors, just like my parents. And, you know, Mr. Rogers taught me, as a member of my community, something that is important to me is that my fellow residents have a safe and secure living situations. It benefits no one but greedy landlords for people to have constantly search for new housing just because their landlord would prefer to pay someone, or would prefer to rent to someone who can pay more. They say, oh, just find a new place to live, but that is by far much easier said than done, and is a statement that comes from ignorance and privilege. I challenge anyone who kicks out their tenants or who raises rents to untenable amounts to find a new place of similar price in the same school district. It's extremely difficult, and when it is possible, it takes many months to accomplish. To kick someone out on their current life just so you can earn an extra $1,000 a month, get yourself a new home is extremely heartless and shows that your parents did not teach you simple rules of fairness and humanity. If you want to be a cutthroat salesperson, go sell stocks on Wall Street with people who can afford to be cutthroat back to you. Don't do it in a way that will damage the life of a family, children. This country is full of opportunities for profit and entrepreneurship. Most of them, no matter how greedy the capitalists, do not rely on tearing communities apart. I have a friend who's a teacher, and she's constantly losing kids who have to move because they get no fault evicted or because their rents get doubled and have to change schools. No child deserves to go to bed wondering if they will have the same place to sleep a month later. Instead, they should be going to sleep wondering if they're going to have a fun snack in their lunch tomorrow, or if the kid in their class that they like will talk to them tomorrow. This is an issue of humanity, and if you think it's okay to kick out good innocent people onto the streets just for some profit, you have none. Thank you for your time.
Hillary, thank you. We appreciate your time. I don't see any questions from members of the committee, so enjoy your morning. Next, we have Lauren Palulis.
Hi, good morning. Senator Marks, Representative Philippe, and members of the Housing Committee. My name is Lauren Palulis, and I'm a resident of New Haven, and I'm a member of the Connecticut Tenant Union. I'm a tenant, and I support HB 6889, an act concerning evictions for cause, and believe all tenants should have just cause eviction protection. Last year, my apartment building organized and unionized because we were put under receivership. But additionally, after talking to each other, we have realized many of us face the same issues regarding needed repairs and maintenance to our apartments. We've had two very absent and negligent receivers, and while we feel stronger together, the fear of an unjust eviction is quite real to people who organize together. Once the initial protections for unionizing are gone, there is nothing preventing our landlord from not renewing our leases one by one. In the past, when I lived in Massachusetts, I've had a landlord move to evict me for simply asking to make a repair. And while I ended up avoiding my eviction, I had to pay a large amount of money to a lawyer. And after the landlord made the repair, he also decided to not renew my lease 5 months later, forcing me to spend time and money searching for another apartment when I would have happily stayed in my last one. As someone who was raised in Connecticut, I think we can do better than Massachusetts to protect our residents from the mercurial nature of a fickle landlord who holds grudges against those or those they see as those who see tenants as checks rather than people who have agreed to provide they've agreed to provide housing to. Currently, thousands of Connecticut residents are at the arbitrary whim of a landlord who they can evict or non-renew their lease for no reason whatsoever. And for tenants who advocate for changes to housing laws, such as those of us who advocating for just cause, we are at odds with many of our landlords. Evictions are expensive and tenants deserve to work and come home with peace of mind that as long as they are minimally good tenants, they can keep a roof over their head until they are ready to move on. And lastly, some landlords will have you believe the law will prevent them from evicting bad actors. I'd implore you to consider that a great majority of Connecticut residents work, hang out, raise their families, and sleep under the radar, paying their rent and maintaining their home in a way most landlords would find unremarkable. Your constituents deserve to have you vote for what's best for them and vote for a law that lets them maintain their house and homes in a way that doesn't cost them thousands of dollars, stress, and cause them to uproot their lives. For these reasons, I strongly support expanding just cause eviction protection. Thank you and have a good morning.
Thank you, Lauren. You have a good morning as well. Next we have Merrill Eaton. Followed by Seth Freeman.
Thank you to the chairs and the members of the Housing Committee. Thank you for raising Bill 6941, which would disregard the income of a child up to age 26 when the parent is applying for the state's rental assistance program. I provide administrative support for Mothers and Others for Justice, New Haven Grassroots Advocacy Group, and we, along with other individuals and organizations, have been lobbying for 3 years for legislation to ease the benefit cliff. Last year, you might remember, we delivered bags of candy on Valentine's Day and pots of gold for St. Patrick's Day to every member of the CGA with postcards highlighting policies that allow people to become more self-sufficient. With New Haven's vacancy rate at 1.3% and the fair market rent around $2,000 to $2,200 for a 2-bedroom apartment, our members' young adult children are not able to move into their own apartments. They're working at Amazon, at big box stores, and in medical offices. Their income is counted as household income, and any safety net funding is reduced disproportionately. We were not able to testify in person today, but 2 members came whose rent increased by 70%, yes, 70% when their children became employed. More frequently, these young adults would like to save money for a security deposit, buy a car, and yet they have to help pay the cost of the new increase. This doesn't happen in more affluent households, so it effectively is penalizing the working poor. This benefit cliff is also a disincentive to work because any increase in household income not only negatively impacts the cost of rent, but also causes reductions in food stamps and ineligibility for SNAP, Husky, and sometimes energy assistance, leaving people worse off. I urge you to vote yes on Bill 6941 and then to speak to your colleagues and fix the benefit cliff so people will have the ability to hold jobs, take on more hours, accept promotions, and get their young adults out of their house and out of their head. Just kidding, not really. Thank you so much for this extraordinary effort you've made.
Thank you, Ms. Eaton, and I hope you enjoy the rest of your morning.
Thank you.
Next is Seth Freeman.
Representative Felipe, Senator Marks, and members of the Housing Committee. My name is Seth Freeman. I'm a resident of West Hartford, president of Congress of Connecticut Community Colleges, 4Cs, and a proud member of Connecticut for All. I'm testifying this morning in strong support of HB 6889, an act concerning eviction for cause. My union, 4Cs, represents community college faculty and staff and faculty at Charter Oak State College. I teach at CT State Capitol in Hartford. In our community colleges, our workforce, and particularly our students, are deeply impacted by housing insecurity. As faculty, we know that housing insecurity and food insecurity are non-academic barriers that impede our students' ability to be successful. 4C's union supports HB 6889 because we know this bill will provide important protections and increase housing security for our workforce and the students we serve. As an individual, I reside in West Hartford, and I'm a property owner in Hartford, where I own a two-family property. As a landlord, I support expanding just cause eviction because I believe renters deserve the same rights and the same dignity that I am afforded as a homeowner. If I pay my mortgage on time, I don't have to worry about the bank taking my property away. Why should we expect anything less for renters? As a landlord, I support expanding just cause protections because it's the just and right thing to do. House Bill 6889 should be supported because it will advance racial and gender justice in our state. Tenants across our state should not live in fear and insecurity, nor face discrimination or harassment for exercising their rights as tenants. Please pass this bill to continue to move our state towards equity, fairness, respect for all residents, regardless of race, gender, or income levels. Thank you very much for your hard work.
Thank you, Mr. Freeman. I hope you enjoy your morning. Next is 268, Kelly Killam. Kelly, are you there?
Yes, hello, are you able to hear me?
Absolutely. Floor is yours.
Okay, great, thank you. Good morning, co-chairs, Representative Felipe, Senator Marks, Ranking Members Scott and Sampson, esteemed members of the committee. Thank you for the opportunity to testify this morning. My name is Kelly Killam. I'm the immediate past president of the Connecticut Apartment Association. We represent over 70,000 apartment homes in the state of Connecticut. I'm a volunteer and I currently live in Portland, Connecticut. I'm here to testify in opposition of multiple proposed legislation initiatives, and I want to share I agree there is a housing crisis, and I have dedicated my entire career to providing housing to residents here in Connecticut, and I hope we can focus together on the issues and ensure a clear pathway to achieve success. HB 6891, an act prohibiting a landlord from requiring security deposit in excess of 1 month's rent. I'm in opposition, and earlier today there was a lot of back and forth on the fact that landlords could take additional security deposit from tenants if the tenants offered. The housing provider in Connecticut cannot do that. They can hold a maximum of 2 months rent today. 2 months has been the max for a significant amount of time, even as costs continue to rise significantly for repairs, even as legal process continues to get more lengthy and continues to be drawn out. Even when in Connecticut, the quit period has been extended and delays the exposure to a housing provider, tenants in support of this legislation lean into the fact that it's way too costly for them to bear. There are agencies that help provide renters the ability to fund for these purposes, and I support those measures where the government wants to create these opportunities. I don't support further regulation reducing to a lesser amount where an owner can't do their own due diligence, where they can't assess the risk and the responsibility to take measures to ensure that they can hopefully pay their bills and their expenses and continue to provide the housing. This will cause a negative impact to housing providers and therefore will be harmful to the renters. There has been a great deal of conversation during this hearing on maintenance, overall deterioration conditions, and tenants' fear of retaliation. As a housing provider, I do agree we need to best maintain the assets, have the means to continue to reinvest, and tenants should not be in fear of retaliation, which I want to reiterate is illegal today. Housing providers need to be able to have the means to maintain the aging housing stock, which in Connecticut has the 5th oldest housing stock in our country. This is a significant part of the problem that Connecticut faces. HB 6891 will continue to hinder this ability. There is a significant lack of supply. The number continues to grow. It's been quoted today as over 100,000 units, which is continuing to grow rapidly. We need to create ways to incentivize developers to build, incentivize municipalities to want more development in their towns, and to tell outside investors that they should come to Connecticut to bring funds into the state to help redevelop the aging stock that is slowly falling offline and reducing opportunities for renters, and which is continuing to age and is undesirable to today's renters in even more deplorable conditions. To tell current in-state housing providers that we don't expect them to bear the huge costs and
Expired. If you can please summarize. Thank you.
so I think that we need to tell current housing providers that we don't expect them to bear the high costs of living that impact every sector alone, meaning housing providers can't be asked to resolve the fact that costs are too expensive for things like housing. Sorry. I guess in recap, I think that Connecticut believes that our organization believes that there are are better ways to incentivize and create development, which means increased supply, which is really what the issue comes down to. So I thank you for the opportunity to testify today, and I welcome any further discussion or questions this morning. You know, this is an extremely important topic that we've continued to ask to be at the table to help resolve, and these measures on the table today are not the answer.
Thank you, Ms. Killam. I don't see any questions from members. I just want to thank you for giving us some time this morning, as late as it is, even though it's technically early. Next is 274, Alexis Terry.
Hi, good morning. Appreciate everyone hearing my testimony. I'm in support of HB 6889, the just cause bill that would expand protections for renters against no-cause evictions. My name is Alexis Terry. Oh, let me just say my affiliation. So I'm a lead organizer with UACT, Unhoused Activist Community Team. I'm also a member of Witnesses to Hunger, New Haven. I also support the work of Just Cause and the Room for All Coalition. Okay. My name is Alexis Terry. I'm a resident of West Haven, and this is my hometown. When I was younger, I lived with my grandparents in West Haven, and they owned a daycare out of their home. They also rented their upstairs apartment as well. I watched them as they conducted their business as landlords. They took their contract agreement seriously, and now as an adult, so do I. They always had tenants who respected them, so I empathize with smaller landlords who don't typically own larger multi-unit buildings. But the reality now is that things are getting beyond out of control, and landlords of larger, older, poorly managed multi-unit buildings take full advantage of the lack of legal protections currently in place that would better protect tenants' rights against no-cause evictions. Some people who own properties tend to want to lean in on the distinctions between bad tenant interactions over the good ones. I don't think they realize that we as tenants aren't inherently inflexible. The majority of us are open to the very costly realities that landlords often face. And yes, I personally know that it sometimes only takes one to ruin things for everyone. What I mean is that there are various groups seeking to find solutions to affordable housing. Sometimes people aren't psychologically equipped for independent housing. Then naturally more actual supportive housing needs to be put in place. With that, there's only one solution for those who need supportive housing. In terms of being a resident who can live independently, we shouldn't be penalized for the lack of adequate protected housing options available with things like no-cause evictions. My first apartment in Hamden was with Ocean Management, and it was a wild ride that I tried to be grateful for while reaching out to the property management, housing case management, and the health department to try to get some help. I remember trying to attend college and focusing on studying complicated concepts. I struggled really hard to focus while constantly having to collect evidence of structural things that were going wrong with the unit and the building in general. I remember what ultimately not being believed did to my mental health and constantly needing to provide more and more evidence that was never believed. 5 years later, during the pandemic, I moved further up Dixwell to a property owned by Natali Management. That was my first no-cause eviction, having to prove that another tenant in an adjoining unit who actually turned out to be employed by the company was breaching his lease agreement by, in different ways, harassing me or targeting me. I complained to the landlord and was ultimately told that they no longer plan to renew my lease.
Your 3 minutes have expired. If you can please summarize. Thank you.
Sure. I just want to say I have extensive experience with being discriminated against for one reason or another, from different, I would call slumlords, maybe from out of state. And maybe that's something that Representative Sampson can't really understand unless it's something that happens to him firsthand. So I wouldn't expect him to understand, but at least be open to meeting us at the table who do have the extensive experience, because we can't all have the same story for nothing. And we need expanded protections. So thank you.
Thank you. We appreciate you joining us this morning.
Mm-hmm.
Next is Javier V.
Good morning, I guess, dear members of the Housing Committee. My name is Javi Villatoro. I am a resident of New Haven, and I'm a member of Semilla Collective of New Haven. I am also a tenant, and I am here to testify in support of HB 6889, an act concerning evictions for cause. And I believe that all tenants should have just cause and eviction protection. I am an immigrant. I've been living in New Haven for 10 years. But my mom has been living here for longer than that, probably like over 25 years. We come from Mexico, and we come here because we were seeking a better future, better opportunities, escaping poverty and even violence. We came to find that there is beautiful community of people here who have been fighting for a long, long time to make this a place that we get to call home now, you know. That's not to say that things have been easy, you know, it's been very challenging, it's been very difficult. At no moment we forgot that we are still seen as the other, that we are still seen as foreigners, you know. We haven't forgotten that we are on a different land, and that this land also has a history. And within that history, this thing called redlining, you know, that makes it so that certain people were only allowed to purchase housing in certain areas, you know. By certain people, I mean people of color. I mean people who look like me, Black people, you know, in certain neighborhoods. So my mom lived in Fairhaven for like 10 years or so, until she was eventually even gentrified out of that area. Eventually, my mom married my dad, a Puerto Rican, and she lives closer to Woodbridge now. Mm, But I tried to move back to Fairhaven a couple times. And it's been very difficult to find housing because of the conditions of the houses there, but also because of the rent prices there. Me, myself, I am living out of Edgewood in New Haven now. And I could only get access to this house because my partner at the time was associated or affiliated with Yale, the school. Because of that, I got access to this apartment. And when we eventually split, I was left paying for this rent by myself for a year. And that was very challenging, very, very difficult because a rent hike put me in a position where I had to decide if I was able to pay the rent here or if I needed to move. I ended up finding a good roommate and I stayed here. However, that just reminded me how close I am to just being outside, you know. Also, there was a moment, you know, where the landlady mentioned that she might need the place for their son. And that is not a good reason for me to be on the street. Neither it is that that I needed to find a roommate to live, you know. It is impossible for you and I or anybody here present tonight to ignore the fact that every day there is more people on the streets. I have volunteered with people like the housing fund in New Haven, doing outreach, speaking to people, and many people were like me, you know, living paycheck to paycheck. And it was just a moment that turned around their lives and put them on the streets. A moment such as an eviction without a just cause. None of us should be up here tonight, this late into the night, hearing about these kind of things. None of us should be awake. But at least we are inside, you know. At least we are not on the streets. There's thousands of people on the state of Connecticut only freezing to death on these temperatures right now. And all of that could have been solved. That was not necessary Housing is a human right. We should be able to, all of us, sleep inside a house and not be cold and not be afraid that if we get sick or that if the rent goes up or that suddenly the landlord needs the house for something else, that we are left without housing. So I urge you today, I urge you to make the right decision. I urge you to take a stance for humanity and support HB 6889, an act concerning evictions for cause. And I also believe that all tenants should have just cause and eviction protection. Thank you.
Oh, hello, can you hear me? Oh, hello. Sorry, I didn't realize it was my turn. My name is Jason. I'm a Teamster with Local 191. I'm here to testify in support of HB 6889. I'll keep this very short. I'm supporting Connecticut Tenants Union in testifying for this bill because I believe in their right to collectively bargain. Due to the lack of interest of landlords across the state to bargain with tenants directly, tenants have come to you, the state legislature, to ask that you step in as mediators and arbitrators to determine what is fair for tenants seeking the right to housing and the ability to bargain with their landlords on an even playing field. This bill would not necessarily even the playing field in favor of tenants. It would just be a small contribution to ensure that they have the right to remain in housing that they have stayed in and made a home in their communities. I have worked in a couple hours, so I will leave it there. And thank you.